ਕਰ ਦਿਓ ਬਸ ਜਿੱਦਾਂ। ਹਾਂਜੀ, ਤੇ ਮਤਲਬ ਮੇਰਾ ਵਿਊ ਇਹ ਹੈ ਕਿ ਜਿਹੜੀ ਪ੍ਰੈਜ਼ੈਂਟ ਵਰਕਿੰਗ ਹੁਣ ਜਿਹੜੀ ਲੇਟੈਸਟ ਦੇਖੀ ਗਈ ਹੈ ਉਸ ਦੇ ਮੁਤਾਬਕ ਅਗਰ ਅਸੀਂ ਚੱਲਦੇ ਹਾਂ ਤੇ ਆਉਣ ਵਾਲੇ ਟਾਈਮ 'ਚ ਅਗਰ ਇਹੀ ਸਿਸਟਮ ਕੰਟੀਨਿਊ ਹੋਇਆ ਤੇ ਇਹ ਬਿਲਕੁਲ ਫਲॉप ਹੋ ਜਾਏਗਾ ਕੰਮ। ਕਿਉਂਕਿ ਅਗਰ ਇਸ ਤਰ੍ਹਾਂ ਦੇ ਆਰਡਰ ਹੋ ਰਹੇ ਨੇ, ਜਿੱਦਾਂ ਹੁਣ ਮੇਰੇ ਕੋਲ ਕਈ ਅਪੀਲਾਂ ਆਈਆਂ ਨੇ ਜਿਹਦੇ ਵਿੱਚ ਕਰੋੜਾਂ ਰੁਪਏ ਦੀ ਐਡੀਸ਼ਨਸ ਹੋ ਗਈਆਂ ਨੇ ਐਂਡ ਦੇयर इज नो ਐਪਲੀਕੇਸ਼ਨ ਆਫ ਮਾਈਂਡ, देयर इज ਐਬਸੋਲੂਟਲੀ नो ਰੀਜ਼ਨ, नो ਕੰਸੀਡਰੇਸ਼ਨ, ਐਕਸ ਪਾਰਟੀ ਆਰਡਰ, ਕੋਈ ਉਹਦਾ ਰੀਜ਼ਨਿੰਗ ਨਹੀਂ ਹੈ, ਕੋਈ ਪ੍ਰੋਸੈਸ ਆਫ ਰੀਜ਼ਨਿੰਗ ਕੀ ਸੀਗਾ ਕੁਝ ਵੀ ਡਿਸਕਸਡ ਨਹੀਂ ਹੈ। और बस एक नोटिस गया, ओदा रेफरेंस पिछला रेफरेंस अगला रेफरेंस, नो रिप्लाई 144 सेक्शन रिप्रोड्यूस्ड एंड एडिशन मेड। इवन सेक्शंस आर नॉट क्लियर कि केड़े सेक्शन करनी है केड़े च नहीं करनी है। और इस तरीके के ऑर्डर्स बड़े सारे आ रहे हैं और इन्हां ऑर्डर्स दे विच सब तो बड़ी प्रॉब्लम आएगी कि स्टे रिकवरी दा की होएगा।
हाँ, इस करके सर आज दा टॉपिक इज बेसिकली उन्होंने ध्यान च रख के लेता ह्यूज डिमांड्स हैव बीन क्रिएटेड एंड असेसी इज हेल्पलेस। और असेसी ਜਿਹੜਾ ਹੁਣ ਕਰੇ ਕੀ ਇਹੀ ਨਹੀਂ ਸਮਝ ਆਉਂਦੀ, ਜਾਂ ਰਿਟ ਕਰੇ ਹਾਈ ਕੋਰਟ ਜਾਵੇ, ਕਿੰਨੇ ਕੇਸ ਜੇ ਹਾਈ ਕੋਰਟ ਚਲ ਜਾਵਾਂਗੇ। ਔਰ ਡਿਪਾਰਟਮੈਂਟ ਜਿੱਦਾਂ ਤੁਸੀਂ ਕਿਹਾ ਕਿ ਕਾਫੀ ਇਹੀ ਲੱਗਦਾ ਕਿ ਆਫੀਸਰਸ ਹੀ ਪਿੱਛੇ ਲੱਗੇ ਹੋਏ ਸ਼ਾਇਦ ਫੇਸਲੈਸ ਦੇ ਅਗੇਂਸਟ ਹੋਣ, ਸਮਥਿੰਗ ਲਾਈਕ ਦੈਟ, ਐਸਾ ਜਸਟ ਲੱਗਦਾ ਹੈ।
ਮੈਂ ਨਾ ਨੈਟ ਦੇ ਵਿੱਚ ਇੱਕ ਲੈਟਰ ਡਾਊਨਲੋਡ ਕੀਤਾ ਸੀ, ਵੈਸੇ ਇਨਸੀਡੈਂਟਲੀ ਮੇਰੇ ਹੱਥ 'ਚ ਇਸ ਵੇਲੇ ਨਹੀਂ ਹੈਗਾ, ਬਟ ਇਨ ਮਾਈ ਲਾਸਟ ਮੀਟਿੰਗ ਇਨ ਦੀ ਜਲੰਧਰ ਬਾਰ ਆਈ ਹੈਡ ਕੋਟਡ ਦੈਟ ਲੈਟਰ। ਇੱਕ ਲੈਟਰ ਇਹਨਾਂ ਦੀ ਐਸੋਸੀਏਸ਼ਨ ਨੇ ਐਡਰੈਸ ਕੀਤਾ ਟੂ ਦੀ CBDT and that letter was addressed on 29th of March 21। ਉਸ ਲੈਟਰ ਦੇ ਵਿੱਚ ਉਹਨਾਂ ਨੇ ਨਾ ਆਪਣੀ ਗ੍ਰੀਵੈਂਸਸ ਲਿਖ ਕੇ ਭੇਜੀਆਂ ਨੇ ਕਿ ਅਸੀਂ ਓਵਰਬਰਡਨਡ ਆ, ਸਾਡੇ ਕੋਲ ਪੂਰਾ ਸਿਸਟਮ ਨਹੀਂ ਹੈ, ਤੁਹਾਡੇ ਜਿਹੜੀ ਐਕਸੈਸ ਟੂ ਯੂਟਿਲਿਟੀਜ਼ ਨਹੀਂ ਹੈਗੀਆਂ ਨੇ ਐਂਡ देयर आर सो मेनी हैंडीकैप्स एंड बिकॉज ऑफ दोज हैंडीकैप्स दे वर नॉट एबल टू कोप अप विद द रश ऑफ वर्क। और प्लस ਉਹਨਾਂ ਨੇ ਇਹ ਕਹਤਾ ਜੀ ਕਿ ਸਾਨੂੰ ਤੁਸੀਂ ਨਵੇਂ 148A ਦੇ ਨੋਟਿਸਸ ਵੀ ਦੇਣ ਵਾਸਤੇ ਕੰਪੈਲ ਕਰਤਾ। ਔਰ ਉਸ ਪੀਰੀਅਡ ਦੇ ਵਿੱਚ 148A ਦੇ ਨੋਟਿਸਸ ਦਾ ਫਲੱਡ ਆਇਆ ਹੋਇਆ ਸੀ। ਔਰ ਵੱਡੀ ਪ੍ਰੋਬਲਮ ਕੀ ਸੀ ਕਿ 148A ਦੇ ਨੋਟਿਸਸ ਜਿਹੜੇ ਨੇ ਦੇ ਰਿਕੁਆਇਰ ਅਪਰੂਵਲ ਆਫ ਦੀ ਹਾਇਰ ਅਥਾਰਟੀ ਆਫ ਦੀ ਕਮਿਸ਼ਨਰ ਔਰ ਚੀਫ ਕਮਿਸ਼ਨਰ ਔਰ whosoever is to grant the sanction at 4 stages। ਇੱਕ ਨੋਟਿਸ ਇਸ਼ੂ ਕਰਨ ਲਈ ਉਹਨੂੰ 3 ਜਾਂ 4 ਵਾਰੀ ਘੱਟੋ ਘੱਟ ਅਪਰੂਵਲ ਚਾਹੀਦੀ ਹੈ। ਸੋ that was also a very lengthy process। So therefore they wrote a very I mean open letter to the CBDT कि we will not be responsible for any laxity in our working or for anything wrong in the orders, even if the appellate forum is to take any adverse view, we will not be responsible। ਉਹਨਾਂ ਨੇ ਆਪਣੇ ਆਪ ਨੂੰ ਡਿਸਕਲੇਮਰ ਪਾ ਕੇ ਭੇਜਿਆ ਕਿ ਅਸੀਂ ਜੋ ਆਰਡਰ ਕਰਾਂਗੇ ਜਿਸ ਤਰ੍ਹਾਂ ਵੀ ਕਰਾਂਗੇ ਉਹਦੇ ਵਾਸਤੇ ਸਾਡੀ ਕੋਈ ਜ਼ਿੰਮੇਵਾਰੀ ਨਹੀਂ। ਔਰ ਉਹਨਾਂ ਨੇ ਕੀ ਕੀਤਾ,
ਇਹ ਵੀ ਪਤਾ ਲੱਗਿਆ ਕਿ ਆਫੀਸਰਸ ਨੇ ਇਹ ਵੀ ਕਿਹਾ ਕਿ ਸਾਡੇ ਨਾਲ ਧੱਕੇ ਨਾਲ ਸੀਨੀਅਰ ਆਫੀਸਰਸ ਨੋਟਿਸ ਕਢਵਾ ਰਹੇ ਆ, ਜਦ ਕਿ ਅਸੀਂ ਡ੍ਰੌਪ ਕਰਨ ਲਈ ਕਹਿੰਦੇ ਪਏ ਆ, ਲੇਕਿਨ ਉਹ ਡ੍ਰੌਪ ਕਰਨ ਦੀ ਬਜਾਏ ਕਹਿੰਦੇ ਤੁਸੀਂ ਨੋਟਿਸ ਇਸ਼ੂ ਕਰੋ, ਰੀਓਪਨ ਕਰੋ।
ਦੇਖੋ ਇਹ ਇੱਕ ਬੜੀ ਮਤਲਬ ਸੀਰੀਅਸ ਜਿਹਾ ਐਲੀਗੇਸ਼ਨ ਹੈ, ਕਿਉਂਕਿ ਪ੍ਰੋਬਲਮ ਇਹ ਹੈ ਕਿ ਜੋ ਮਕੈਨੀਕਲ ਵਰਕਿੰਗ ਸਾਡੇ ਸਿਸਟਮ 'ਚ ਪਹਿਲਾਂ ਵੀ ਬਣੀ ਹੋਈ ਸੀ ਉਹਦੇ ਵਿੱਚ ਕੀ ਸੀਗਾ ਕਿ ਇੱਕ ਵਾਰੀ ਅਗਰ ITO ਕੋਲ ਇਨਫੋਰਮੇਸ਼ਨ ਆ ਗਈ ਹੈ, ਹੁਣ ਤਾਂ ਜਿਹੜਾ ਇਹਨਾਂ ਨੇ ਸਿਸਟਮ ਬਣਾਤਾ ਹੈ ਕਿ ਇਨਸਾਈਟ ਦੇ ਪੋਰਟਲ ਦੇ ਵਿੱਚ ਆ ਗਈ ਹੈ ਤੇ ਇਹ ਉਹਨੇ ਪਕੜ ਕੇ ਤੁਹਾਨੂੰ ਨੋਟਿਸ ਭੇਜ ਦੇਣਾ। ਔਰ ਕੋਈ ਵੀ ਇਹ ਜਿਹੜਾ ਹੈ ਨਾ ਉਹਦੇ ਉੱਤੇ ਬਹੁਤਾ ਰਿਸਕ ਨਹੀਂ ਲੈਣਾ ਚਾਹੁੰਦਾ ਕਿ ਹੁਣ ਮੈਂ ਮਤਲਬ ਆਈ ਐਮ ਵੰਡਰਿੰਗ, ਮੇਰੇ ਕੋਲ ਹੁਣ ਮੈਂ ਇੱਕ ਰਿਟ ਫਾਈਲ ਕੀਤੀ ਹੈ ਇਨ ਦੀ ਹਾਈ ਕੋਰਟ, ਮੇਰੇ ਕੋਲ 2-3 ਰਿਟਸ ਫਾਈਲ ਕਰ ਰਿਹਾ ਮੈਂ ਇਨ ਦੀ ਹਾਈ ਕੋਰਟ ਅਗੇਂਸਟ 148A ਨੋਟਿਸਿਸ। ਕਿ 148A ਦੇ ਨੋਟਿਸਿਸ ਦੇ ਵਿੱਚ ਦੇਖੋ ਐਸ ਪਰ ਕਲੌਜ਼ B ਦੇ ਹੈਵ ਟੂ ਗਿਵ ਅਸ ਅ ਸ਼ੋ ਕਾਜ਼ ਨੋਟਿਸ ਬਿਫੋਰ ਦੇ ਇਨਵੋਕ 148। ਹੁਣ ਉਹ ਸ਼ੋ ਕਾਜ਼ ਨੋਟਿਸ 'ਚ ਮੈਨੂੰ ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ these items have escaped assessment according to information with us। ਹੁਣ ਜਦੋਂ ਮੈਂ ਉਹਨਾਂ ਨੂੰ ਰਿਪਲਾਈ ਦੇ ਰਿਹਾ ਕਿ all these items are part of my income return, ਤੇ ਉਹ ਕੀ ਕਰਦੇ ਨੇ ਕਿ C ਨੋਟਿਸ ਉਹਨਾਂ ਨੇ ਕੰਸੀਡਰ ਕਰਨਾ ਤੇ D ਦੇ ਵਿੱਚ they are supposed to pass an order before issue of notice, or that order has to accompany notice under 148 and that order has to be passed with the approval of the commissioner। ਔਰ ਉਸ ਆਰਡਰ ਦੇ ਵਿੱਚ ਕੀ ਕਰ ਰਹੇ ਨੇ, ਫਨੀ ਕੇਸ ਸੀ ਕਿ ਮੇਰੇ ਇੱਕ ਕੇਸ ਦੇ ਵਿੱਚ ਮੈਂ ਹੁਣ ਅੱਜ ਹੀ ਉਹਦੇ ਰਿਟ ਫਾਈਨਲ ਕੀਤੀ ਹੈ, ਆਈ ਵਿਲ ਬੀ ਫਾਈਲਿੰਗ ਇਟ ਔਨ ਮੰਡੇ, ਕਿ 2.5 ਕਰੋੜ ਰੁਪਇਆ ਕਹਿੰਦਾ ਜੀ ਤੁਸੀਂ ਲੋਨ ਦਿੱਤਾ ਆ ਟੂ ਅਨਦਰ ਕੰਸਰਨ ਐਂਡ ਦੈਟ ਲੋਨ ਹੈਜ਼ ਨਾਟ ਬੀਨ ਸ਼ੋਨ in the return of income, that has escaped assessment। Now that is the issue which was not even part of the notice under B। So I felt very bad about it कि एक procedure ਜਿਹੜਾ law 'ਚ ਬਣਾਇਆ ਗਿਆ ਉਹ procedure ਤੇ ਤੁਸੀਂ ਸਿੱਟਤਾ ਹਵਾ ਜੀ। B ਦੇ ਵਿੱਚ ਤੁਸੀਂ ਮੈਨੂੰ notice ਦੇ ਰਹੇ ਹੋ ਕਿ these are the 4 items which are not in the income return and these are escaping assessment, but in the ultimate order you are you are just not pointing out those 4 items, now you are coming up with a new item and that new item they say is not reported and therefore it is income liable to tax, escaping assessment with the approval of chief commissioner। I really wonder what was the chief commissioner doing when earlier it was allowed to be noticed under clause B, and then what was considered by the AO and what order has been passed by the AO. एक आइटम ਜਿਹੜੀ ਤੁਸੀਂ ਮੈਨੂੰ ਕਨਫਰੰਟ ਹੀ ਨਹੀਂ ਕਰ ਰਹੇ, ਔਰ ਉਸ ਆਈਟਮ ਤੇ ਤੁਸੀਂ ਮੈਨੂੰ ਨੋਟਿਸ ਦੇ ਰਹੇ ਹੋ 148 ਦਾ ਫਾਈਨਲੀ, ਤੇ what is this all going on? ਮਤਲਬ ਐਪਲੀਕੇਸ਼ਨ ਆਫ ਮਾਈਂਡ ਦਾ ਇੱਕ ਬਹੁਤ ਛੋਟਾ ਵਰਡ ਹੋ ਜਾਂਦਾ ਹੈ, ਮਤਲਬ ਇਟ ਇਜ਼ ਟੋਟਲੀ ਰੁਥਲੈਸ, ਰਾਦਰ ਆਈ ਵਿਲ ਸੇ ਕਿ ਮਤਲਬ ਉਹਨਾਂ ਨੂੰ ਪਤਾ ਹੀ ਨਹੀਂ ਕੀ ਹੋ ਰਿਹਾ। ਇਸ ਤਰੀਕੇ ਦੇ ਨੋਟਿਸਿਸ ਆ ਰਹੇ ਨੇ, ਔਰ ਇਹ 148A ਦੇ ਹੁਣ ਦੇਖੋ ਆਈ ਐਮ ਸ਼ੋਰ ਕਿ ਜਿੱਦਾਂ ਹਾਈ ਕੋਰਟ ਪਹਿਲਾਂ ਓਵਰਬਰਡਨ ਹੋਈ ਸੀ ਵਿਦ 148 ਨੋਟਿਸ ਰਿਟ ਪਟੀਸ਼ਨਸ ਅਗੇਂਸਟ 148 ਨੋਟਿਸਿਸ, ਨਾਓ देयर इज ਲਾਈਕਲੀ ਟੂ ਬੀ ਅ ਫਲੱਡ ਆਫ ਕੇਸਿਸ ਅਗੇਂਸਟ 148A ਨੋਟਿਸਿਸ ਆਲਸੋ, ਕਿਉਂਕਿ ਉਹਦੇ 'ਚ ਕੋਈ ਰੀਜ਼ਨ ਪ੍ਰੋਪਰ ਸਾਈਨ ਨਹੀਂ ਹੋ ਰਿਹਾ, ਕੋਈ ਆਰਡਰ ਪਾਸ ਨਹੀਂ ਹੋ ਰਿਹਾ, ਕੋਈ ਪ੍ਰੋਪਰ ਬਿਲਕੁਲ ਹੀ ਟੋਟਲ ਮਕੈਨੀਕਲ ਕੰਮ ਹੋ ਰਹੇ ਨੇ, ਔਰ ਇਨਫੋਰਮੇਸ਼ਨ ਇਹਨਾਂ ਕੋਲ ਇੰਨੀ ਪਈ ਹੈ ਕਿ ਮਤਲਬ they cannot meet that information within the time they have. So मतलब आने वाले टाइम च ना litigation is likely to be much more than what we expect or what we expected. ਹੁਣ ਮੈਂ ਪੜ੍ਹ ਰਿਹਾ ਸੀ ਫਾਈਨਾਂਸ ਮਿਨਿਸਟਰ ਦੀ ਸਪੀਚ ਵੀ, ਮੈਂ ਆਪਣੀ ਰਿਟ ਦੇ ਵਿੱਚ ਪਾ ਕੇ ਭੇਜੀ ਕਿ in 2021 ਬਿੱਲ ਜਿਹੜਾ ਪੇਸ਼ ਕੀਤਾ ਸੀ ਮੈਡਮ ਨੇ, ਫਾਈਨਾਂਸ ਮਿਨਿਸਟਰ ਨੇ, ਉਹਦੇ ਵਿੱਚ ਉਹਨੇ ਲਿਖਿਆ ਜੀ ਕਿ we are reforming the tax laws. All the amendments are being made with the objective of reformation, and the reforming of act is with the object to simplify the tax administration. Number one, ease of business. Number two, and reduce litigation. Number three. Now, these are the three objectives. Now, the question is कि even for 148A also they said कि पहला 10 साल होके लटके रहते सी. Now we are reducing the period to 3 years, and only in exceptional cases it will be for 10 years. Where the escapement is more than 50 lakhs, and that too with the approval of the highest authorities, chief commissioner or principal chief commissioner. So these objectives, but the notices now we are receiving, nowhere those objectives are reflective. And other ji objectives ਹਵਾ 'ਚ ਹੀ ਸੀਗੇ, ਬਸ ਐਵੇਂ ਗੱਲਾਂ ਹੀ ਨੇ, ਮਤਲਬ ਇਟਸ ਆਲ ਰਿਹੈਟੋਰਿਕ, ਮਤਲਬ ਕਹਿਣ ਨੂੰ political stunt ਜਿੱਦਾਂ ਹੁੰਦਾ ਨਾ, it is that way of working ਕਿ you make declarations and make declarations, but when it comes to implementation things are not.
ਹੋਇਆ ਕਿ ਮੈਨੂੰ ਇਹ ਲੱਗ ਰਿਹਾ ਕਿ ਇਹ ਜਿਹੜਾ ਫੇਸਲੈਸ ਹੈ ਨਾ
ਜੀ,
ਸਿਸਟਮ ਨੂੰ ਫੇਲ ਕਰਨ ਲਈ ਕਾਫੀ ਐਫਰਟਸ ਜਾਂ ਲੋਬਿੰਗ ਹੋ ਰਹੀ ਹੈ। ਮੈਨੂੰ ਅੱਜ ਜਿਹੜੇ ਜੋ ਕੁਝ ਵੀ ਹੋਇਆ ਪਿਛਲੇ ਮਾਰਚ 15-20 ਤੋਂ ਬਾਅਦ ਜਾਂ 10 ਮਾਰਚ ਤੋਂ ਲੈ ਕੇ 10 ਅਪ੍ਰੈਲ ਤੱਕ, ਉਹ ਕੁਝ ਡਿਫਰੈਂਟ ਕਹਾਣੀ ਹੀ ਸ਼ੋ ਕਰਦਾ ਪਿਆ, ਜਿੱਦਾਂ
ਇਟਸ ਅ ਲਾਰਜ ਸਕੇਲ ਕਨਸਪੀਰੇਸੀ ਇਫ ਵੀ ਸੇ
close to be like that.
It's like a conspiracy, because even the departmental people are not happy with this system. They want that manual system to be brought back. So for that reason also perhaps they are trying to create hurdles कि भाई इदा नहीं हो सकता, मुश्किल है, ये है वो है. But I feel कि ਜਿਹੜੇ last year orders ਆਏ ਸੀਗੇ, ਉਹ ਇਸ time this time ਜਿਹੜੇ order ਹੋਏ ਨੇ, ਉਹਨਾਂ ਤੋਂ last time the orders were much better, more reasonable, and still ਮਤਲਬ ਜਿਨ੍ਹਾਂ ਦੇ ਵਿੱਚ ਅਸੀਂ ਕਹਿ ਸਕਦੇ ਹਾਂ ਕਿ some application of mind was there, replies were considered, opportunities were given, show cause notices were given with adequate time to respond also. ਇਹ ਸਾਰੀ ਤਾਂ 23 ਤਰੀਕ ਨੂੰ ਨੋਟਿਸ ਆ ਰਿਹਾ, 24 ਨੂੰ ਜਵਾਬ ਦੇ ਦਿਓ ਜੀ, ਔਰ ਮਤਲਬ ਇੱਕ ਦਿਨ ਦਾ ਟਾਈਮ ਵੀ ਨਹੀਂ ਕਈ ਜਗ੍ਹਾ ਦਿੱਤਾ ਉਹਨਾਂ ਨੇ, ਮਤਲਬ ਬੜਾ ਅਜੀਬ ਜਿਹੀ ਵਰਕਿੰਗ ਹੋਈ ਹੈ ਇਸ ਵਾਰੀ, ਕਾਫੀ ਪਰੇਸ਼ਾਨੀ ਹੋਈ ਹੈ।
ਚਲੋ ਉਹਦੇ ਨਾਲ ਆਪਾਂ ਇੱਕ ਡਿਸਕਸ਼ਨ ਪਹਿਲਾਂ ਕੀਤੀ, ਮੈਨੂੰ ਲੱਗ ਰਿਹਾ ਕਿ ਰਾਜੀਵ ਜੀ ਆਪਾਂ ਨੂੰ ਇਸ ਟੌਪਿਕ ਤੇ ਵੀ ਦੁਬਾਰਾ ਇੱਕ ਵਾਰੀ ਡਿਸਕਸ਼ਨ ਦੀ ਜ਼ਰੂਰਤ ਹੋ ਸਕਦਾ। ਅਸੀਂ ਜਲੰਧਰ ਬ੍ਰਾਂਚ ਔਰ ਲੁਧਿਆਣਾ ਬ੍ਰਾਂਚ ਜਾਂ ਇੱਦਾਂ ਸਾਰੇ ਸੀਨੀਅਰਸ ਮਿਲ ਕੇ ਕੁਝ ਜਿੱਦਾਂ ਵਸੀਨ ਸਾਹਿਬ ਹੈ ਜਾਂ ਹੋਰ ਸਾਡੇ ਲੁਧਿਆਣੇ ਦੇ ਕੁਝ ਸੀਨੀਅਰ ਬੰਦੇ ਇੰਟਰਸਟਡ ਹੋਣ, ਬੈਠ ਕੇ ਇੱਕ ਸਟ੍ਰੈਟਜੀ ਚਾਰਟ ਆਊਟ ਹੋਰ ਕਰ ਲਈ, ਜਿਹੜਾ ਅਸੀਂ ਕਰਦੇ ਪਏ, ਮੈਂ ਦੱਸਦਾ ਹੁਣ ਥੋੜੀ ਦੇਰ ਚ। ਬਾਕੀ ਚਲੋ ਮੇਰਾ ਖਿਆਲ ਮੇਰੀ 4:20 ਹੋ ਗਿਆ। I think should we start the topic?
जी सर, we should come to the topic also.
कुछ कहने लगे थे या कि
नहीं जैन साहब एक इनपुट यही है, क्योंकि गल सारी पसीन साहब ने की है। पसीन साहब एक रिक्वेस्ट है कि एज अ प्रोफेशनल फ्रेटर्निटी साडा रोल अंडर द गिवन सेट ऑफ सर्कमस्टांसिस की बनदा, ਉਹਦੇ ਤੇ ਆਪਾਂ ਗੱਲ ਕਰਾਂਗੇ ਬਾਅਦ ਚ, ਔਰ 10 ਮਿੰਟ ਲਾਵਾਂਗੇ ਆਪਸ ਦੇ ਵਿੱਚ, ਸੋ ਦੈਟ ਵੀ ਮਸਟ ਪਲੇ ਆਰ ਰੋਲ। ਬਾਕੀ ਤਾਂ ਜੋ ਹੁਣ ਸਿਸਟਮ ਨੇ ਜੋ ਚੱਲਣਾ ਉਹ ਚੱਲੇ ਉਸ ਢੰਗ ਨਾਲ। ਤੇ ਜੈਨ ਸਾਹਿਬ ਆਪਾਂ ਸ਼ੁਰੂ ਕਰੀਏ।
ਹਾਂ, ਬਿਕੋਜ਼ ਇਟ ਇਜ਼ ਆਲਰੇਡੀ 4:20, 4 ਤੱਕ ਪੇਮੈਂਟ ਹੋ ਗਏ ਹੈ। ਹਾਂਜੀ ਹਾਂਜੀ ਠੀਕ ਹੈ
जी सर, जी कर दिए जी सर।
मोहित जी प्लीज start the proceeding.
जी सर, good evening everyone. Before starting I would like to say a quote: the capacity to learn is a gift, the ability to learn is a skill, and the willingness to learn is a choice. And for completion of this choice of our members, we are trying to arrange study circle meetings regularly on different topics, especially topics which are currently more relevant. In this year's study circle meeting, we will be covering legal, procedural, and practical aspects on stay of demand and recovery proceedings. This meeting will be conducted under the guidance of our convener Rajiv Kaushalji, and technical things will be carried out by Anshulji. Queries and question and answer session will be taken up by Gulshan Badwaji and Rajiv Sharmaji. Members can raise their queries in the chat box or by raise of hand. I would request our members that the queries would be taken after the speaker has completed the deliberation. Members, I would also like to bring in your knowledge that we are shifting from the Zoom platform to WebEx platform from the next meeting. For this, we will be sharing a link for WebEx so that all the members could install it in the mobile or the PC, and mobile number of 2 of our executive members will be shared for any technical help in its installation and working. Now, I would invite our President, C.S. Subhash Jainji, to formally welcome our guest speaker and members. Please, sir.
Thank you, Mohitji. First of all, I thank you everybody for joining, particularly Advocate J.S. Bhasin ji. I just gave him a ring a few days back, and he agreed on the spot that I will be taking up that topic. Though this topic is just little untouched, but still he said, "No, I will prepare and I will do that. I will do that webinar." Welcome, Bhasin Sahab. Thank you very much for accepting our invitation and being speaker for this topic. I also welcome, I think there are about 70 members who are present at present, and I welcome all of you. And before I hand over the mic back to Secretary for the today's proceedings, I would certainly like to share a few things which we have been doing during this month, April activities. I think that is important because just Mr. Bhasin was telling about the system of working in the department related to 148A and related to faceless assessments. We at the DTBA had a meeting on 7th of April in the bar room where legal advisory team of our DTBA was there with Mr. Rajiv Kaushal, convener of the study circle, and editor of the newsletter, Mr. Harish Aneja was there. So we discussed different issues which was arising out of the system that was under section 148A in the department and faceless assessments. And we decided that a representation needs to be sent to the concerned authorities. So before that, we just wanted to have a view of the department also. So we met Chief Commissioner of Income Tax, Madam Poonam Sidhu ji. We had a detailed meeting with her. She was informed about the grievances and about the problem being faced by the members and by the assessees, because whatever has happened, what Mr. Bhasin was telling, it has given a bad image about the department. And I think with bad image, no department can work. We as professionals need to work, and we are working for that there should be a building of the nation. There is a nation we are working in the nation building. But the way the assessments have been made, the way cases have been reopened, I think this system of faceless, otherwise is very good. It saves time of the professionals. It leads us to corruption-free environment, and there are other advantages also. Although there are few disadvantages also related to opportunities and related to explaining the things in person, but overall system I think is good. But the way it has been handled, it may become, instead of faceless, it may become baseless. And we as professionals need to do our bit that it doesn't become baseless. In case there is any request from the members that it should be a one-to-one meeting, it should be there. We will be taking up this matter. Then we also we also tried to have a meeting with the FM, and for that we met Mr. Bikram Singh Sidhu, who was a BJP candidate for assembly elections. He assured us that he will be meeting FM finance minister, and he will be arranging a meeting with the finance minister. We discussed the issues with him. He was also of the opinion that अगर ऐसे काम कैसे चलेगा, ये तो देश का भुट्टा उठाने वाली बात हो जाएगी. तो let's hope for the best. जलंधर में भी जैसे ये एक चर्चा चल रही है, और I think all over India this discussion, this deliberation is going on, that what has happened should not have happened. The assessment जो हुई है वो ऐसे नहीं होनी चाहिए, जो नहीं हुई, जिसमें एडिशन जो हुई वो ऐसे होगी कि जैसे बस डिपार्टमेंट का काम सिर्फ पैसे उड़ाने का ही होता है, और एडिशन जैसे होगी एसएससी हैज बिकम हेल्पलेस, कंप्लीटली हेल्पलेस. अब जाकर हाई कोर्ट में जाए या फिर डिमांड्स के लिए पीछे भागता रहे अफसरों के कि डिमांड स्टे कर दो, डिमांड की रिकवरी ना हो. वो इतनी हैवी डिमांड्स हो गई है कि कुछ लोग तो ये एसएससी कह रहा है कि मेरा बिजनेस तक बंद हो जाएगा अगर मेरे सारे एसेट्स भी कंप्लीट कर लोगे, तो भी शायद इतनी अमाउंट ना बढ़े जितनी डिमांड क्रिएट हो गई है. छोटे छोटे एसएससी जो बड़ी डिमांड हो गई है, इवन बड़ा एसएससी जो उसके बड़ी डिमांड हो गई है. सो इस सारे इश्यूज को ध्यान में रखते हुए वी डिसाइडेड दैट वी शुड हैव डिस्कशन ऑन हाउ टू गेट द स्टे, हाउ टू फेस द रिकवरी प्रोसीडिंग्स. For that, we requested Mr. J.S. Basin, advocate. He's from Jalandhar. So he agreed that today we will be deliberating on this issue of stay and recovery proceeding. And in respect of departments working, we are alive, and we as a team will be taking up the matters with the highest authorities. And I think there should be something good will come out. And thank you very much for, again, I welcome all of you. It is already 4:28, and now I think it is already delayed. Request the secretary to continue the proceedings. Thank you very much. Thank you again.
Thank you, sir. Thank you for the welcome. Now I would invite our executive member, C.A. Sangam Garji, to formally introduce our guest speaker.
Thank you, Mohit. Our speaker for today's session, Advocate J.S. Basin ji, is a law graduate and postgraduate from Guru Nanak Dev University. He is a member of District Bar Association Jalandhar. Presently, he is also holding the post of Joint Secretary of Jalandhar Income Tax Bar Association. He has a vast experience of more than 30 years practicing as an income tax advocate. He has specialized in the field of handling variety of search seizure matters and appellate matters before the Income Tax Authority. Recognizing his professional attributes, he was also nominated by Ministry of Finance through CBDT as a regular member of Regional Direct Tax Advisory Committee in the year 2019. Thank you, sir, for coming. Over to Mohit ji.
Sir, it's already late. I think I must hand over the mic to Basin ji for his deliberations. Sir, please.
Thank you, Mohit. So, to start with, I am really grateful to the President, Mr. Jain, and also to Mr. Mohit Gupta, Secretary, and Mr. Rajiv Kaushal, who have been in touch with me for the last almost a week to get into this deliberation for today. I am grateful to all of you for having chosen me for this deliberation. And it's really a pleasure to be with a bar of such elite members. All learned people are there, all the members. And the topic, if I come straight to the topic now, because we are now getting late. Am I audible?
Yes, sir. Yes.
Because I'm not able to see the video of others now.
Yes, sir. You are audible, sir.
So,
We are comfortable with it.
So now the topic we have selected for today's deliberation is the stay and recovery of the demand. Now the point for consideration is at what point of time the question of stay will come up and how we have to proceed further. The first thing which is required for the purpose of stay is that there has to be a demand notice. A valid demand notice is required to be served by the department, by the ITO, on the SSE in a manner known to the law. Unless a demand notice is properly served, there cannot be any demand against the assessor. So the first requirement is that we have a demand notice under 156, and that demand notice will bear the demand in the nature of tax or interest or fine or penalty, etc., etc. Anything. Even under section 143(1) or 201 and 1A also, the intimation received is as good as a demand notice under 156, and even that demand is also enforceable. After the demand notice is received, the demand notice itself gives you a time of 30 days to make the payment. And in that period, there is likely to be no disturbance by the AO. No coercive measure, nothing can be there. And within 13 days, the assessee has the choice, if he is aggrieved, to file an appeal. He may not file an appeal also if he is not aggrieved. So if aggrieved, he may file an appeal. Now, the point at which the assessee is to be treated as assessee in default. For that, we have to refer to section 220 of the Act. 221. 221 of the Act says that any amount otherwise than by advance tax specified as payable in the notice of demand under 156 shall be paid within 30 days of the service of the notice at the place and to the person mentioned in the notice. So within 30 days, if we have preferred an appeal, then after 30 days, we can be treated as assessee in default unless the demand is stayed by the AO. And under subsection 2, when the demand is payable, the assessee is also liable to pay interest at the rate of 1% for every month till the tip payment is made. So even that part of interest also becomes a demand in notice under 156, which may be subsequently raised. Now there are two situations. There is subsection 3 in section 220, subsection 3, which is also relevant here, which says, now there are two things. One is that if I file an appeal, then the position is different. And if I don't file an appeal, then also there is a different situation. Subsection 3 of 220 deals with a situation where an application is made by the assessee before the expiry of the due date under subsection 1. The AO may extend the time for payment or allow payment of installments subject to such conditions as he may think fit to impose in the circumstances of the case. Now, this subsection 3 does not refer to the appeal to be filed by assessee. It is not, if we look at subsection 6, that talks of a situation where an appeal has been filed. Subsection 3, which I think we hardly ever invoke this subsection 3, but we can invoke this subsection 3 also, which says that without prejudice to the provisions contained in subsection 2, on an application made by the assessee before the expiry of due date under subsection 1, that means before 30 days, if I file an application before the AO, that I may be given extension in time for payment, or I may be allowed payment by installments subject to such conditions. The AO can give me installments, or he can extend my time beyond 30 days. But this section does not talk of appeal. That means if supposing I don't want to file an appeal and there is a demand, then I can invoke subsection 3, in which I can request the AO to give me extended period or to give me installments. And it is again the AO's discretion, subject to conditions which he may impose. He can give that extension or he can give you the installments. Now, if we refer to circulars and other things which we come across very normally, this subsection 3 is not covered by any of the circulars. Therefore, this subsection 3 is an independent provision where there is no appeal, but still there is a demand and we have to pay that. We can seek the benefit of this subsection. Then subsection 6 comes into play, where it says that once an appeal has been presented under section 246, then the AO may in his discretion and subject to such conditions as he may think fit to impose in the circumstances of the case, treat the assessee as not being in default in respect of the amount in dispute in appeal, even though the time for payment has expired, as long as such appeal remains undisposed of. Now, the language of this subsection 6, it may be seen, which is very dicey also, that the language of subsection 6 is very cryptic. Cryptic in the sense that it does not empower the AO to grant you unconditional stay. It simply says that you, assessee, will not be treated in default in respect of the amount which is mentioned in notice under 156. That means there is no provision for stay at all. The language of this section was also the subject matter of consideration before the Supreme Court in the case of Muhammad Khuni, that was 71 ITR old. This is a very old law. The 71 ITR 815 of Supreme Court. This language was there before the Supreme Court, and in that case, the matter was with regard to stay to be granted by the tribunal, because at that time the power of tribunal was also not there to grant stay. There was, but for this subsection 6, there was absolutely no power with any authority to grant stay. So therefore, the matter went to the Supreme Court, and there the Supreme Court, after considering the whole of all these conditions, then they said that the power of tribunal is inherent, it is ancillary, and it is accidental to the power of appellate to jurisdiction. So therefore, they allowed tribunal to grant stay. But there also, I have read, when they discussed various decisions of different high courts, and then there was one AP High Court decision where some judge had made out a point that the language of subsection 6 is very cryptic. It does not give power to stay. It does not even say that the AO can grant you installments. It does not even say that the AO can give you any relaxation, or he can ask you for any security. So this language itself is very vague. And therefore, they said this needs to be reconsidered. But in any case, the Supreme Court said that the power is there with the AO, but even the tribunal is also vested with the power. So I'm talking of the language used in this. Because of this language that the CBDT has come up with various circulars from time to time. And those circulars have been issued by the CBDT at different stages and at different points of time. And even those circulars have not been able to settle the dispute between the assessee and the assessing officer or the departmental authorities as to how and to what extent the demand should be paid or it should be recovered. And therefore, it is still going on. Although the history, if I go back to the history of these circulars, then the first item which has come to my notice is that there was an instruction number 96 dated 21/8/1969. The first instruction was on the recommendation of the informal consultative committee of Parliament and on the assurance of the Deputy Prime Minister of India at that point of time. It was assured that where any high pitched assessment is made, and that high pitch was illustrated in the sense that where the return income is
सर एक मिनट मोहित जी कुछ म्यूट कर दो
जी सर डन
भसीन साहब कंटिन्यू करो
भसीन साहब अनम्यूट कर लो सर प्लीज भसीन साहब अनम्यूट कर लो प्लीज अनम्यूट कर लो
हाँ जी
जी सर
ठीक है सर.
So I was talking to the instructions which have been issued from time to time. The first instruction which has come to my notice is 96, instruction number 96 of 21/8/1969. And that was the instruction which was issued after the matter was considered by the informal consultative committee of Parliament and the then Deputy Prime Minister, Finance Minister of India. And in that instruction, it was finally held or said that where any assessment is made making a substantial addition to the return income, and that substantial was illustrated as being double the income returned. So if the income, whatever is the return income, and the assessed income is twice the amount of the return income, that was taken as a high-pitched assessment. And in that event, it was laid down that no recovery will be made and the demand will be stayed till the disposal of first appeal. So that instruction was not in favor of the revenue, because in every other case, there used to be such type of a claim, and therefore subsequently the CBDT issued various circulars from time to time. And then with so many, then one instruction of number 1914 of 2/12/93 was issued, and then also some conditions were laid down and discretions were given to the AO with some conditions to grant stay according to his discretion. So gradually the matter traveled further, and finally the instruction number, it is not an instruction, it is an office memo dated 29/2/2016, which has been issued by the government. as a general rule that AO shall grant stay on 50% payment till disposal of first appeal, but maybe more or less. Now this, if we talk of the present day scenario, then we have this instruction of 29/2/2016, and this instruction has been further revised by another instruction dated 31st July 2017. So as on date, the AO deals with the stay petition only qua these two instructions. One is dated 29/2/2016 and the other is 31st July 2017. So if I have a look at these instructions, the one issued in 2017, 31st July 2017, there is nothing altered, but for the fact that the 15% has been enhanced to 20%. That is the only change. So finally, the present day position is that the AO, if you apply for stay, will give you a conditional stay that you deposit 20%, and the rest of the demand will be stayed up to the disposal of first appeal. This is how the present scene continues. Now, so far as the present position is concerned, even the instruction of 2016, 29/2/2016, even in that instruction, what are the conditions which are before the AO? Now it says that where the outstanding demand is disputed before the CIT appeal, the AO shall grant stay of demand till disposal of first appeal on payment of 15% of the disputed demand, unless the case falls in the category of clause B. So therefore, under clause A, he will straightway give you an order to pay 15%, and then the rest of the demand is to be stayed till first appeal. Now this 15% is to be read as 20%. In a situation, in B, clause B, what it says that in a situation where the AO is of the view that the nature of addition resulting in the disputed demand is such that payment of lump sum amount higher than 15% is warranted, then even the higher demand can be raised for depositing before the stay is granted. But the situation is that it is a case where the addition on the same issue has been confirmed by appellate authorities in earlier years, or the decision of Supreme Court or jurisdictional high court is in favor of the revenue, or addition is based on credible evidence or collected in search or survey operation. So these are the conditions under which the AO can require you to pay more than 20% also. That means this does not give in a flat rate of 15 or 20% to the AO. It can be subject to increase or decrease. Now he can increase this amount where the order of the jurisdictional high court or the Supreme Court is in favor of the revenue, and otherwise an addition has been made on the basis of credible evidence found in search and survey. And in other condition where it can be less than 20% also, where the case in addition same issue has been deleted by the appellate authorities in earlier years, or the decision of Supreme Court or jurisdictional high court is in favor of the assessor, then the AO shall refer the matter to the administrative principal CIT or CIT, who after considering all relevant facts shall decide the quantum proportionate of demand to be paid by the assessee as lump sum payment for granting a stay of the balance demand. So the situations are that even under the present day office memorandum of 2017 or of 2016, the AO has the power to increase or decrease the amount minimum level of 20%. It can be more or less also in the given situation. Then if the AO does not agree to our request and he enforces us to make payment of 20% in all cases, then we can file an application with the administrative principal CIT for a review. And the principal CIT can consider my request for either granting complete stay or for granting installments also, because the AO has not been empowered to grant installments. If we move an application to the AO, he will say pay 20%, but he will not give you installments because the circular does not authorize him to give you installments. So in that event, we may have to move my application to the principal CIT, and CIT may consider whether the installments can be given or any other amount less than 20% can be granted. But he can even reject also. And in both the processes, the time bound exercise is within 2 weeks to be done. AO has to dispose of my application within 2 weeks. And similarly, if I go to the CIT or principal CIT, he too has to dispose of my application within 2 weeks. But here also, when the stay is granted, he can impose further conditions. he can require an assessee to cooperate in early disposal of appeal, failing which the stay order will be cancelled. He reserves the right to review the order after 6 months. A review, earlier there was no power with the AO to review. Once a stay is granted, that was final till the disposal of appeal. Now, after 6 months, he can review the order. He can review the stay according to the situation, that if there is any further development on the issue involved, if there is any higher authority has taken a view contrary to the view earlier taken, which goes in the favor of the department, he can cancel the stay granted also. And he reserves the right to adjust the refunds also against the demand to the extent of amount required for granting stay and subject to the provisions of 245. Now here it is to be seen that when he is to adjust my refunds, the question arises that quite often it is seen that if supposing I have paid 20% and still my refunds are adjusted, that means it will go beyond 20%. So we have to ensure that if I have paid 20%, no further refund can be adjusted against the disputed demand, the rest of the demand, because that stands stayed. So if any action is taken by the AO or by the CPC or by any other authority in retaining my refund, even after my paying 20% the disputed amount, that refund cannot be retained, and we can lawfully and authoritatively plead with the authorities to release our refund. So this is how this operates. Now the subsequent office memorandum of was issued on 31st July 2017, where they say that the earlier office memorandum of 2016 was reviewed because of the fact that there was a feedback. Now this is very wonderful what they have written in the circular. They say that the matter has been reviewed by the board in the light of feedback received from field authorities. Now what is the feedback? That the board efforts, in view of the board efforts to contain overpitched assessments through several measures, resulting in fairer and more reasonable assessment orders. The standard rate of 15% of the disputed demand is found to be on the lower side. Accordingly, it has been decided that the standard rate of prescribed in the OM dated 29/2/16 is revised to 20%. And then there is another clarification issued, Office Memorandum of 25/8/2017, which says that this 20% will be prospective and it will not apply to the stays granted earlier prior to the revised instruction dated 31st July 2017. This is to understand that if any stay has been granted before 31st July 2017, that was for 15% only, and the AO cannot press you for 20% because of the subsequent enhancement made by the board. So this has been clarified by the board itself via its office memorandum dated 25/8/2017. But the point to be noted here is that this escalation of 15 to 20 was for the feedback that because of the efforts of the board to contain overpitched assessments through several measures, resulting in fairer and more reasonable assessment orders. Now this point needs to be underlined, as Mr. Jain was just saying, that we should take up this matter with the board, that if that was the view taken to enhance the amount of deposit from 15 to 20%, then the present day scene in the latest orders which have been passed, high pitched assessment orders, where there is no quality of assessment orders, the orders are in a very bad shape, then they should review this and bring back this 20 to 15%, because that is the only reason given to increase it from 15 to 20%. There is no other reason given. So we need to have a look at this. The reason assigned itself justifies the latest development of the departmental working, that the 20% should be brought down to 15% or maybe even less than that. So this is the position of the present day circular. Now the question is how to get the desired results. Now AOs, most of the times, if you move an application to the AO, he will say that you first deposit the amount and then come to me. Now, if I look at the circular, it has been misread by the AOs. It doesn't say that you have to first deposit 15% or 20% and then to approach the AO. Because if it is so, then where is the occasion with the AO to see that he can increase my deposit from 15 to 20% or maybe a higher amount, or he can decrease it from 15%. If I have already paid 15 or 20% and then I move an application to the AO, then the requirement or the conditions or the situations which have been given in these circulars, these become redundant, because he has to see according to the decision of the High Court or Supreme Court or the earlier appellate authorities, if whether they are in my favor or they are against me. And if they are in my favor, then he can decide for a lower amount. If they are against me, he can decide for a higher amount. Therefore, the pre-deposit condition This is not the mandate of these circulars. So we have to be very clear on this point that after 30 days, when we file an application, we don't need to make a deposit of 20% of our own at the first go. If it is comfortable for us, if we are happy, we are enjoying enough money with us, and we are financially in a position to pay, then okay, you pay the whole of 20% and then stay the demand, get the demand stayed. But here it has to be seen that the AO will not, but sometimes it may happen. We may play tricks. I mean, it can be a tricky situation. Supposing I know that the issue which has been decided against me is already against me by my judicial high court or by Supreme Court or in my earlier cases, and there if I play smart that I pay 20% and make a request to the AO, यार मैंने पे कर दिया, आप stay कर दो. And if the AO stays the demand, then that is contrary to what the circular says. That will be a favor to the assessee or favor to the council or favor whatever may we say. So it means that we do not need to go for a pre-deposit. We have to deposit it only after the application is considered and after I am required by the AO. And that requirement has to be by rejecting my application by way of a speaking order. Now the question is what application I have to file. Most of the times what we do, we take it very casually. I have seen applications which are filed. Most of the times we simply say that we have filed an appeal. Therefore, the demand may be stayed till the disposal of it. This 2 lines stay application is made. Normally, this is what we do. And perhaps we do so because we feel, as a professional, I also feel that sometimes the assessee is not paying us for all these things. You are paid for assessment work, you are paid for appellate work, but you are not paid for these miscellaneous work. Therefore, normally, in normal circumstances, I have seen most of the people taking it very casually. And for that reason, we get a casual order from the AO also. And for that reason, we suffer also. So in fact, we have to make out a proper application for stay, make out a prima facie case for stay. Yes, the issue involved is so and so, and I have a good case to succeed in appeal. And if I am able to convince the AO, even if the AO is not convinced, I should make out my application in such a way that supposing if I have to file a writ in the High Court, then what is before the High Court? Your application for stay is before the High Court and the order passed by the AO, or for that matter by the CIT. If I have moved my application to the CIT, my application before the AO, before the CIT, and the order of the AO or the CIT rejecting my application is what is going to be the material before the High Court. Therefore, if at all we think in small cases, we may not worry much, but in higher or bigger cases where the demand is abnormally high, then we have to be very seriously draft our application. We have to make out a proper case, not only on the merits of the additions made, then we have to make out a case also as to what is my financial position. If I am financially very tight, I have to project the figures with evidence. If supposing I say that I have been running into losses in my earlier years also, if continuously my business is in losses, I must give the projections also that last year my income was this much, this time it is this much, this time it is this much. And if it is a high pitched assessment, then we should make out a case that way. If the income assessed is on the very much higher side, twice or thrice or maybe many more times of that income return, then what is the position of my loans in my balance sheet, what my balance sheet shows, whether I have a lot of debtors or creditors or whatever my status financially is, what is my cash in hand position, what are my assets, what are my liabilities. We should make out a proper case that we are financially also very tight. Any pressure or any recovery, if forced to be made by the TRO or by the AO, that will put me in further distress, that will result in the closure of my business. We must keep in mind that the object of the law is not to close my business. They do not want the assessee to die because it is a golden hen. It lays eggs. They have to eat the eggs. They cannot say that we are going to butcher the hen itself. So we have to make out a case in a way that we are financially also very tight. And on merits also, we have a good case to argue. And then the balance of convenience. The third point is, what is the balance of convenience? What is balance of convenience? We have to make out a case that the balance of convenience is also in my side, because if the demand is not paid, the department is not going to die, because it's a huge department. What is department? Department is government. Government keeps on running. Even if there are substantial losses in the government, this government still survives, but the assessee cannot survive. If supposing there's a huge demand, supposing say if the assessee has a turnover of say rupees 2 crores and the demand is 10 crores, and if I'm made to pay the amount of 10 crores, that will result either in closure of my business, or it will result in losses in my business, or it will put undue hardship, genuine hardship to me. So looking into these facts, even the balance of convenience we can make in our favor, and therefore we can stress upon the AO to deal with our application in a way which should lead to passing of a speaking order. Why should he not accept my application? He has to pass a speaking order. Normally what happens? Normally AO will entertain your application and he will say your application received, considered and rejected. Pay 20%, rest demand will be stayed, or pay any X amount which he may decide according to the facts, according to the board circular, or according to the discretion. Now what is the discretion? See, the discretion which is given to the AO is not to be exercised in a capricious manner or in an arbitrary manner. It's a judicial discretion. It has to be judicially exercised. It is to be, if supposing we go to the High Court, then the discretion of the AO will be tested by the High Court also on the principles of law, because he is tasked with a duty also. AO, what is the duty of the AO? He is there to defend the cause of the revenue. First duty is, of course, he has to be a pro-revenue because he's a revenue authority. But at the same time, he is tasked with a holy duty to be fair to the assessee also, because he himself is the prosecutor and he himself is the adjudicator. The problem is that he himself is the prosecutor and adjudicator. So therefore, he cannot be harsh to me. He has to be very fair and reasonable and take a view which should be very genuine in the given facts and circumstances of the case. Therefore, the important thing is that we must draft an application which must be, by making out our case on merits also, on financial problems also, on balance of convenience also. And if in earlier years something has been decided in my favor, that must also be brought to the notice of the AO, that the same issue was there in the earlier orders also, that was decided in my favor. Or if it was not taken in appeal in earlier years, what was the reason for that reason? Whether that becomes a res judicata. Sometimes it happens that in an earlier year we have not gone in appeal and the same issue crops up in the second year. Then they say that you have already accepted that addition. How can you dispute in the second year? So each year is separate year. We can dispute, and therefore we should make out a proper case on merits. And by that application, then if rejected, of course, if the demand is low or if it's a small case, then we may not go to High Court because it is expensive going to the High Court also. But in cases where the demand is abnormally high and it is really going to affect my finances, and the orders passed by the authorities below are really not speaking or most arbitrary, then the only choice is that we should go to the High Court by way of a writ. And the High Court normally, now what happens before the High Court? Under 226, the power of the High Court to entertain a writ, High Courts normally do not exercise their power to grant absolute stay. In number of cases which are reported every now and then, day in and day out, there are cases which are even against the present board circulars also. And in hardly any case, the High Court has granted this stay, because the High Court is not going to exercise their power against the revenue. They will simply send you back to the AO with the direction. What is the direction? Now, we can quote a number of cases. Recently, I have come across the case of the Honorable Supreme Court, and I'll just refer to that case. That is of the Principal CIT versus LG Electronics India Private Limited. Now, in this case, it was probably a case of penalty. In this case, the AO had levied penalty of rupees 32 crores. There was a demand of 32 crores in the case of LG Electronics India Private Limited versus Principal CIT. This has been reported in 303 CTR Supreme Court 649. This is on the latest circular of 2016 and 17. And there the demand was 32 crores and 15% was directed to be paid by the AO. The assessee went to the CIT, and even CIT also did not accept the prayer of the assessee, and he said no business, pay 20% and rest demand is stayed. Then the matter went to the High Court. Assessee went to the High Court in writ, and the High Court said that the order of CIT is without reasons, not addressing the central issue, unsustainable in law, because the CIT never addressed the issue, because that was a case of penalty, and in that case the assessee had raised the issue that the penalty was time barred. 275(1)(a). That was the main contention of the assessee, that a huge penalty of 32 crores was time barred. That was a serious allegation. But the CIT field did not give any finding on that and did not even adjudicate on that issue. And therefore the High Court said that the central issue was not touched by the CIT. And therefore they said that it is unsustainable in law, and therefore they sent the matter back to the CIT with the direction to reconsider. And the direction of the High Court was, don't look into that office memo of 31st July 2017. High Court said to the CIT in that case that forget this board circular, apply your mind independent of that, and then grant this stay. Not happy with the order of the High Court, the department went to the Supreme Court. SLP was filed, and the SLP was taken up by the Supreme Court. And what finally the Supreme Court says, it's a very short order, of course, but what is the content of the order? Having heard Shri Vikramjit Banerjee, learned ASC, appearing on behalf of the appellant, and giving credence to the fact that he has argued before us that the administrative circular will not operate as a fetter on the commissioner, since it is a quasi-judicial authority, we only need to clarify that in all cases like the present, it will be open to the authorities on the facts of individual cases to grant deposit orders of a lesser amount than 20% pending appeal. The appeal is disposed of accordingly. Now, this is very short and swift order, but it is very to the point. What it says that we only need to clarify that in all cases like the present, it will be open to the authorities on the facts of individual cases to grant deposit orders of a lesser amount than 20%. That means the ceiling of this 20%, this has been lifted by the Honorable Supreme Court. Now, it is not necessary, it is not mandatory that 20% has to be deposited. It says that individual cases, fact position of individual cases has to be seen to grant lesser amount, order for lesser amount, less than 20%. This can be any amount. This can be 20% or maybe 15%, maybe 10%. Of course, it cannot be zero. It cannot be zero, but it can be any percent, maybe 1%, maybe 5%, according to the facts of the case. So the point is that we have to make out a good application, and we have to see and make out a convincing case for a stay of a demand. And if still they do not agree, then the remedy is only High Court. And if still not happy, we may go to the Supreme Court, because in this case, normally the High Courts are with the SSC. There are cases, I have gone through a case where they said that when a speaking order is passed by the AO, that is also a dangerous trend, that if you advise the AO to pass a very speaking order, then the High Court will not entertain it. It is only if such mechanical orders are passed that we have a good case before the High Court. In one of the cases, that was, I think, before Delhi High Court, I have seen that where a proper order was passed by the AO dealing with all the issues raised by the SSC, then they said that we cannot interfere. He has taken a plausible view rather. So in any case, we have to make out a good application, and we should seek an order from the AO or from the commissioner. Now we can move the commissioner also. And now the question is that if whether we should file an application for stay or not. This is also an issue. How to deal with situations. There is no provision in 226 within what time I should file my application for stay. There is no provision by what time I should file my application for stay. The only provision is that I will be treated as assessee in default after 30 days. Now, after 30 days, if I am treated in my own cases, I have recently come across 2-3 cases where there is a demand of about 4-5 crores, 10 crores, 15 crores. And I know that the AOs are not very smart, not very active, because present day, there is another problem in the present day situation. After the faceless assessment, who is the AO? The demand is created by the NFSC. And as per the procedure laid down under section 144B for the faceless assessment, after the faceless assessment is over, then the matter goes to the jurisdictional officer. Now, jurisdictional AO will take cognizance of your recovery, your demand, your after subsequent actions, subsequent to whatever has been done by the NFSC in assessment. Now, the AO will go for attachment, whether he will give you a notice under 221, by what time he will give. What I mean to say is that although it is risky, but I feel that in certain situations we can file the application late also. Although as per law, after 30 days, I am already SSC in default. And in that situation, because the AO is expected to issue me a show cause notice for making payment before he makes an attachment. Any attachment made without a notice will be otherwise bad in law. It is even if I have not filed an application for stay of demand, AO cannot of his own attach any of my accounts or go for the recovery. He has to give me a notice. Now, what happens in the case of demands and the stay? I'll refer to some more sections also, because the relevant sections are to be seen, which are to be implemented in law. And then there is one provision of penalties. 221. Then when assessee is in default as deemed to be in default in making payment of tax, he shall, in addition to the amount of arrears, amount of interest under 222, he will be liable to penalty to pay such amount as the AO may direct, and it in continuing default such further amounts or amounts. So, however, that the total amount of penalty does not exceed amount of tax in arrears. 221 penalty fear is always there if I do not apply for stay. But even in that situation, he will give me a notice before levying a penalty. So we can immediately apply for stay. Now, what happens that nowadays, in addition to AO, it is the TRO who comes into operation soon after the demand is created and soon after the demand is due after 30 days. Now, under section 222, bracket 1, where assessee is in default or is deemed to be in default in making the payment of tax, the TRO may draw is under his signatures a statement in the prescribed form specifying the amount of arrears due, which is as per the second schedule referred to as certificate. This is that under section 222, the TRO can draw a certificate of demand, arrear of demand, and then it is the TRO who will come into picture and he will proceed with the recovery in accordance with the rules laid down in the second schedule. And what are the powers with him? He can go for attachment and sale of assessee's movable property. He can go for attachment and sale of assessee's immovable property, and he can even arrest the assessee and his detention in prison, appointing a receiver for the management of assessee's movable and immovable properties. Now, these are the powers with the with the TRO. Now, the TRO, after he draws a certificate, what he will do, then Schedule 2 comes into operation. Schedule 2 is annexed to the Income Tax Act itself, and I believe we hardly ever look into it. I do not know how much of my brothers in profession have gone through this schedule, because I have also personally not very often gone through it. Only a few sections are the rules are seen. So if the TRO comes into operation, then he will give you a notice first. Then a first notice which he has to issue in second schedule, that has to be as per rule 2, issue of notice. When a certificate is drawn by the TRO for the recovery of arrears, the TRO shall cause to be served upon the defaulter a notice requiring the defaulter to pay the amount specified in the certificate within 15 days from the date of service of the notice, and intimating that in defaults, steps would be taken to realize the amount under the schedule. So that means the TRO will give you 15 days notice before he proceeds to effect recovery by any of the modes which are available. The modes are very fearsome. Of course, you can go for attachment of your movable, immovable, and he can go for detention also. That is the power with only the TRO, not with any other authority in the income tax law. So, but here also one thing is very clear, that this notice which is to be issued under Rule 2 has to be served on the assessee. If notice is not served, the jurisdiction of the TRO will not come into effect. Now, the service of notice again has to be according to the law 281 to whatever provisions apply to the service of other notices under the law. The same law will apply in respect of the service of this notice also. Therefore, the TRO has to ensure that a proper service is made, not by saying that I have served the notice on this man, that man, or somebody else, and that way the concerned defaulter is also now aware of my notice. That is not a service. A service means a service on the defaulter. The assessee deemed to be in default has to be served in a way which is known to the law, and then only the TRO can proceed further. So after the notice has been served, now I refer back to section. Before I jump over to that, there are few more sections which are very important and relevant. See, if the TRO comes into operation, there is one provision which is very important and which we hardly ever use. This may be noted, please. 225 bracket 1. This provision section itself says that it shall be lawful for the TRO to grant time for the payment of any tax, and when he does so, he shall stay the proceedings for the recovery of such tax until the expiry of the time so granted. Now, if we read this provision of law, I think we have never applied this. I do not know how many of you have applied, but at least I have once applied this. I applied it on 1 or 2 occasions, but the TRO was himself not aware कि what is this. I made him aware that you have the power. He was surprised to see, यार अच्छा हमने तो कभी देखा ही नहीं है section. Most of the TROs are not educated because normally the TROs are not interested in that job. It is the punishment posting. The TRO is a punishment posting. Normally it is taken as that. Like DR in the tribunal, so the TRO in the department. So in any case, 225(1) gives the power to the TRO to grant time. Now the question is, what time is to be granted? No board circular I have come across which clarifies what is this time period to be granted by the TRO. And this says that he shall stay the proceedings for recovery. It is better worded. It is better worded than section 2206. Because there he says the AO will not treat the assessee in default, but here he says that he shall stay the proceedings for recovery. That means the AO has more clear power under the law to stay the recovery, and we must exercise this jurisdiction of the TRO and write to him that since see that you have the power and you grant us time to. Now, what happens in one of the cases or in one of the situations I have read somewhere that the assessee played very smart with the TRO. What he did? He requested the TRO, grant me time, sir, give me 2 months to make the payment. The amount is very high, I need 2 months. He gave him 2 months. He said, give me another 2 months. Then this way he got extensions and extensions. And finally, he got extensions till the disposal of appeal. It is an indirect way of getting a stay from the TRO, from the recovery, because once the TRO has taken over as the, after drawing the certificate, of course, he has the power to grant me stay. So it is one of the provisions which are very favorable to the assessee, and we must invoke. Because of lesser invoking of this provision, there is not much of the judicial decisions also on this provision. So if we invoke this provision, only then we can come to know of what implications are there. But since it is there in the law and TRO is directly in the picture, therefore, if he has been empowered under the law, we must invoke his jurisdiction. And then other mode of recovery, section 226(1). This is very important. This is the only section under which the attachments are made, other than what is in the schedule 2. Normally the AO or the TRO also, because this is the power. Here it says that where no certificate has been drawn up under 222, the AO may recover the tax by any one or more of the modes provided in this section. 1A says that where the certificate has been drawn up under 222, the TRO may, without prejudice to the modes of recovery specified in that section, recover the tax by any one or more of the modes provided in this section. So this is the section under which the attachments are made. Now, what can be attached? Subsection 2, 226(2) says that if the assessee is in receipt of salary, he may require, the AO or the TRO may require any person paying the same to deduct from any payment subsequent to the date of such requisition any areas of tax due from such assessee, and such person shall comply with any such requisition and shall pay the sum so deducted to the credit. That means it is attachment of the salary, and the notice will go to the employer. The employer is supposed to make payment to.
Sir, आपका
Hello. So the salaries are attached. Then the employer is under obligation to.
Sir,
but condition attached to this section that any part of salary exempt from attachment in execution of a decree of a civil under section 60 of the Code of Civil Procedure 9085 shall be exempt from any requisition made under this subsection. The salary, whole of the salary cannot be attached. There is a provision under the CPC section 16 and which says that in case of salary, the employer can, to what extent the attachment is, 1,000 first amount is not to be attached, and then 2/3 of the rest amount is not to be attached. The rest of the amount is only to be attached and paid to the AO or to the TR. Then subsection 3. Subsection 3 is the very common section which is used by the TRO or by the AO, and subsection 3 has as many as 1, 2, 3, 4, up to 10 clauses. There are 10 clauses attached to subsection 3. The AO may at any time to time by notice and writing require any person from whom money is due or may become due to the assessee, or any person who holds or may subsequently hold money for or on account of the assessee to pay to the AO or to the TRO forthwith upon money becoming due or being held or at or within the time specified in the notice, so much of the money as is sufficient. Now this section says that if there is any money payable to the defaulter, to the assessee in default by any person, AO can issue notice to that person to pay that amount directly to the AO to the extent the amount is due. And then subsection 2 says that it may be issued to any person. Notice under this section may be issued to any person who holds or may subsequently hold any money or on account of the assessee jointly with any other person. And for the purposes of this section, the shares of joint holders in such account shall be presumed until the contrary is proved to be equal. So where there is a joint account holder, joint money, then also to the extent of the assessee, treating that as equal, that can be recovered. Then important point is that any notice which is issued under section 226(3), subclause 3 says that a copy of that notice shall be forwarded to the assessee at his last address known to the AO or to the TRO, and in the case of a joint account, to all the joint holders at their last address is known to the AO, meaning thereby that if my bank account is attached or any of my debtor is attached, then the copy of the notice must also be sent to me. What happens that in most of the cases, we do not receive a notice. The TRO or the AO, they send a notice directly to the bank. There is no intimation to the assessee, and the assessee gets a telephonic call or intimation from the bank that your account has been attached. That is not lawful, that is illegal, and that can be a matter of challenge, because clause 3 is very clear that a copy has to be given to the assessee of any such notice issued to anybody. Likewise, if there is any notice issued to the bank or to the post office or to any insurer, then they say that there is nothing required, no passbook, no deposit receipt, no policy or anything, and simply endorsement. They can directly send the amount to the AO or to the TRO. Then it says that any claim respecting any property in relation to which a notice under this subsection has been issued arising after the date of notice shall be void as against any demand contained in the notice. Any claim is made in respect of the demand after the issue of notice is void, meaning thereby that they have the first charge. Nobody can claim that amount subsequently. And if supposing a notice is sent to the debtor or to the bank or to anybody for recovery, and that man objects that there is nothing payable to that man, then he can file an objection with the AO or to the TRO, and to the extent of that liability will be deleted. If he says that I have not to make payment to the extent you have said, I have to pay lesser than amount, then it will be rectified accordingly. Or if he denies and he can prove that yes, it is really not so, then the notice can be withdrawn. After any amount which is recovered by the AO or the TRO, they have to issue a receipt, proper receipt. Most of the times what happens that whatever department recovery are made, at subsequent situation when there is a appeal effect order given, most of the times we do not have evidence of what amounts have been recovered by the AO or by the TRO, and quite a few times the refunds are held up. So they are supposed to give a receipt of each and every recovery made by them, either by AO or by the TRO. So we must ensure to get a proper receipt. Whenever any attachment recovery is made from the bank, they are supposed to issue a challan for that, acknowledging the receipt of it. And then there is a harsh provision. If any person discharging any liability to the assessee after the receipt of notice under this subsection shall be personally liable to the AO or TRO to the extent of his own liability to the assessee, so discharge or to the extent of assessee liability for any sum under due under. This is very simple. If supposing I have to make payment of rupees any X amount to a defaulter assessee, and there is an attachment notice on me, but I still make a payment to the assessee in default, then that means I am liable to the TRO. I cannot make any payment once I get a notice from the TRO of any amount which I have to make to the assessee in default. So once I receive a notice, I must not make any payment. And if at all I have to make a payment, I must seek permission of the TRO or the AO. Because if supposing they say that, okay, now you can go ahead, we have recovered the amount from elsewhere, then he may give you a clearance. But without his clearance, if we make the payment and he runs away, then we are liable. We are also to be treated as assessee in default. And last clause 10 says that if the person to whom a notice under subsection is sent fails to make the payment in pursuance thereof to the AO or to the TRO, he shall be deemed to be an assessee in default in respect of the amount specified in the notice, and further proceedings may be taken against him for the realization of the amount as if it were an arrear of tax due from him in the manner which is provided under section 22 to 25, and the notice shall have the same effect as an attachment by a debt of a debt by the TRO in exercise of powers under section 222. The AO officer may apply to the court in whose custody. Now there is a further provision of subsection 4. This section 226 has a vast power with the AO. Now in addition to going to the bank, in addition to going to my debtors and to others, it also says that the AO or the TRO can apply to the court in whose custody there is a money belonging to the assessee for payment to him of the entire amount of such money, or if it is more than that tax due, then an amount sufficient to discharge the tax. Now, what is this situation? This situation is that if any court is seized of the money, maybe by way of a seizure or by whatever method, sometimes it happens that there is a seizure of money by the police. Court, then the TRO can approach and the court is bound to make the payment to the TRO or the and then subsection 5 says that with the permission of CIT or principal CIT or chief commissioner by journal or special order, recover any arrears of tax due from an assessee by distraint and sale of his movable property in the manner as laid down in the third schedule. This is another provision of distraint only. Then there is one more important section which we hardly ever look into, which is rarely looked into. That is section 228 capital A. This is also an important in the present day scene because of the lot of foreign incomes, and it says that where an agreement is entered into by the central government with the government of any country outside India for recovery of income tax under this act, and the corresponding law in force in that country, and the government of that country or any authority under the government which is specified in this behalf in such agreements, send to the board a certificate for recovery of any tax due under such circumstances, such corresponding law from a resident or a person having any property in India, the board may forward such certificate to TRO. Now what this says, that if there is any tax liability of a person outside India and there is an agreement with that country of the government of India, then that country or through their channel, they will send the demand to the board, CBDT, and the CBDT will send that as a recovery certificate to the AO or to the TRO. And then that TRO having jurisdiction over that property in India, he can effect recovery of that demand. He can proceed with in the same manner as under section 222. And then he will remit the sum so recovered by him to the board after deducting his expenses in connection with the recovery. That means that any demand of the outside country also, any foreign country demand can also be raised and recovered through the board, and the TRO or the AO concerned having jurisdiction over the assessee here will be liable to make the payment. Then there is another situation also in the same section. Subsection 2 says that where an assessee in default is deemed to be in default in making a payment of tax, the TRO may, if the assessee is resident of a country, being country within which the certificate of government has entered into an agreement and the corresponding law, or has any property in that country, forward the board to the board a certificate drawn by him under 222, and the board may take such action thereon it may seem appropriate for having regard to the terms of the agreement of such country. That means that if a person is having property in the foreign country and that property has come to the notice of the board, then a certificate can be drawn and sent to that country for recovery by attachment of that property even in the foreign country. So this means that the recovery in respect of any demand which is created in India and the property of the assessee is situated outside India, even that can be done. And if a foreign country demand has been raised, even that can be recovered under these provisions of the law under 222(8)(a). There is one more provision where it says that TRO, if supposing I am based at Ludhiana and I have property in Ludhiana, which is not sufficient to meet the demand. But I have a property also in Jalandhar or in Amritsar or elsewhere in India. Then in that situation, the TRO can send the certificate to the TRO of that place where my property is situated. And that TRO can effect recovery by liquidation of that property also. That means the AO is able to gather, or the TRO is able to gather information in respect of any of my properties situated anywhere in India or world over. My recovery can be effected from any of these properties. Now I will come to the Schedule 3 also. Schedule 2, sorry, this is Schedule 2. Now Schedule 2 is important in the sense that that has a vast powers of the TRO defined in that schedule. TRO has been given very vast powers to effect recovery by way of sale, by way of attachment, by way of detention, and so on. And normally, one thing which is very important for us to note is that under Rule 83, quite often we receive summons from the TRO. All of you must have received these summons, because whenever the matter travels to TRO after an initial notice under Rule 2, giving you 15 days time, and you don't comply with it, or you comply with it but don't make the payment, then the TRO is empowered to issue you summons. Now the language of this rule, what it says, this language, if you ever receive any notice or the summon from the TRO, he will say that your attendance is required, as if it is a summon under Section 131. Section 131 summon whenever issued, that mandates that the person to whom the summon is issued, he is supposed to appear before the authority concerned, and he is not to leave his office without his permission. And in case of any default, penalty of 10,000 is to be levied. Now, contrary to that, the language of this rule is very different. Now, it starts with the head note, power to take evidence. It is power to take evidence. Then Rule 83 says that every principal chief commissioner, commissioner or principal commissioner or tax recovery officer or the other officer acting under the provisions of this schedule shall have the powers of a civil court while trying a suit for the purpose of receiving evidence, administering oaths, enforcing the attendance of witnesses, and compelling the production of documents. Now, the language of this section nowhere says that the TRO can summon the assessee to be present personally before him. The language is acting under the provisions of this schedule shall have the powers of a civil court while trying a suit for the purpose of receiving evidence, administering oaths, enforcing the attendance of the witnesses, and compelling the production of documents. This means that the TRO can compel you to file evidence in the shape of documents, enforcing the attendance of witnesses. Now, it is for the purpose of witnesses, attendance, enforcing. It doesn't say that it can enforce the attendance of the assessee in default. So normally when we receive a summon from the TRO, it is so worded that you have to personally attend my office. So the assessee becomes scary when he gets a summon from the TRO. Yeah, this requires personal attendance, and most of us also say that yes, you will have to appear, and if you don't appear, then the consequences are likely to be very dire. But the language of the law is not so worded. So therefore, we can always object that you can enforce attendance of a witness, or you can compel the filing of documents. Now, what can be said? Okay, when a summon is received, this assessee can authorize his counsel, CA, advocate, whosoever, to go to the TRO and give him the evidence. Now, what evidence he has to gather from you? Now, he has to gather evidence in respect of the properties you are holding, in respect of the money you have, in respect of your credibility, in respect of your liquidity, your cash book, your ledger. He can examine your cash book also to find out what is your cash in hand, what is the present day state of your affairs. Because supposing the demand pertains to an year much prior to the present day, maybe it relates to 10 years back, maybe 5 years back, I may be in a different situation today. I can be in a much better situation than earlier 5 years, or I can be in the worst situation than the earlier years. So he has to gather the evidence, and on the basis of that evidence, he has to draw his working. He has to draw how to proceed further, whether to attach the properties or to arrest the person or to take any other remedial action. So This 83 rule says as that the assessee cannot be compelled to make personal affairs. But contrary to this plain language of the section, I have come across a case of Gujarat High Court. Now, Honorable Gujarat High Court was seized of a matter in the same situation. And the Gujarat High Court in the case of Molek Kumar Vinod Kumar Patel versus TRO, it is 189 DTR 413 Gujarat 2020. And in that case, the assessee had challenged the summon of the TRO under 83 rule schedule 2 to enforce personal attendance of the assessee. Now, what the High Court has said, the High Court has taken a contrary view, not in favor of assessee, but against the assessee. Now, it has said, I have read this order and I was just wondering that the High Court is taking a very strange view, because they are saying that TRO can compel the personal attendance of the assessee defaulter, since it is the case of TRO that for the purpose of proceeding further with the recovery, it is necessary to collect relevant information and details as regards the movable and immovable properties of the assessee. And for that purpose, his presence is required. It cannot be contended by the assessee that his personal attendance should not be insisted. And that whatever information is required, the same shall be furnished by him through his legal representative or his chartered accountant. It was in connection with the notice of demand under 156 and pending recovery proceedings, the summons under Rule 83 came to be served upon the assessee. There is no merit in the assessee's submission that since no proceedings could be said to be pending on the date before the ITO who passed the assessment order, the summons under Rule 83 of the second schedule could not have been issued. Submission of the assessee that Rules 83 Schedule 2 only talks about enforcing the attendance of the witness and not the assessee himself is also not tenable. When the assessee appears before the TRO in response to such summons issued to him under Rule 83, he could be said to be a witness. Mere absence of word assessee or defaulter would not make any difference. Even if it is assumed that the impugned summons issued under Rule 83 of Schedule 2 insisting for a personal attendance of the assessee is illegal. Now the High Court itself says that even if we assume that it is illegal, that means there is some illegality in that notice. But still the High Court is saying that the assessee is not entitled to as he has not cooperated with the AO. No, hello. Now what the position in this case is that the High Court was moved with the facts of that case because the assessee in that case had not cooperated with the AO in assessment proceedings as evident from the assessment order. It is in the aforesaid set of circumstances that AO had to issue the summons under Rule 83 of the second schedule calling for necessary information for the purpose of recovery of the demand along with penalty. Hence, no case is made out by the assessee for declaring the summons as illegal or erroneous in law. Now, if I go by the facts of this case, the High Court itself is saying that since the assessee never cooperated when he never appeared before the AO, then he had no case to come and say that he will not even appear before the TRO. So therefore, the court has taken a view contrary to the provision of the relevant Rule 83 of Schedule 2, which does not say that the assessee must personally appear before the TRO. It is only says that the documents are to be filed and the evidences can be enforced. So what I gather from this judgment also, that it is in the peculiar facts of that case that if you do not cooperate before the AO also, then the TRO can enforce your attendance. This is how the High Court has tried to interpret this provision. But if the plain language of that rule is same, it doesn't require the personal attendance of the assessee in default. So therefore, this summon whenever received for personal appearance can be contested by making out a case on the plain language of the provision itself, that it does not empower the TRO, and let him justify that he has the power. But at least we can start with this objection, yes, the summon is not for, we have to provide information, of course. Now, if he says that you produce your cash book, your ledger or accounts or bank accounts, that we cannot deny, because he has to see my status, financial status, whether I am in a position to make payment or not. But if supposing we are really in a very bad shape, if my assets are not there, if my cash in hand is not there, I have a financial crunch, then there is no harm in producing all those evidence before the TRO, so that he may not proceed with those coercive conditions. So this is Rule 83, which is important and which is normally there. And then there is a provision which is of detention. This is a harsh provision, but it is very rarely used. Now it says that custody, now this is rule 75 of schedule 2, pending the conclusion of the inquiry, the TRO may in his discretion order the defaulter to be detained in the custody of such officer as the tax recovery officer may think fit, or release him on his furnishing security to the satisfaction of the TRO for his appearance when required. Now 76(1) says order of detention upon the conclusion. This inquiry means he has to make an inquiry before making any attachment, before selling your property, auction and other things. And if in the meantime he comes across a situation, during the pending the conclusion of the inquiry, he can even effect the custody also, detention also. So upon the conclusion of inquiry, if the TRO may make an order for the detention of the defaulter in civil prison and shall in that event cause him to be arrested if he is not already under arrest, provided that in order to give the defaulter an opportunity of satisfying the arrears, the tax recovery officer may, before making the order of detention, leave the defaulter in the custody of the officer arresting him or any other officer for a specified period not exceeding 15 days, or release him on his furnishing the security to the satisfaction of the TRO for his appearance at the expiry of the specified period if the arrears are not so satisfied. So detention in and release from prison, every person detained, now rule 77(1) says that every person detained in civil prison in execution of a certificate may be so detained where the certificate is for a demand of an amount exceeding 250 rupees. This amount is very, very low, just for 250 rupees for a period of 6 months, and in any other case for a period of 6 weeks, provided that he shall be released from such detention on the amount mentioned in the warrant of his detention being paid to the officer in charge of the civil prison, or on the request of the TRO on any ground other than grounds mentioned in 78 and 79. So this is the provision for detention, but this detention is only to compel the assessee to make the payment. And what happens that whenever any person is arrested, I do not know how many occasions you have seen when the person is arrested, but once in a while arrest is made. I witnessed one arrest was made in Jalandhar about 20 years back, and the person was arrested and brought to the department, and he was put in a cell in the department only, and that was only to create a fear. And immediately on his retention, somebody from his relations or somebody from his circle, he came with the request to release him, and he offered to make the payment. So the moment the payment was received, he was detained for a few hours and then he was released. Basically, it is meant to simply create a fear so that the assessee who are really not willing to pay, they may make the payment. Now, there are several other similar provisions in Schedule 2. It is basically meant for the TRO, how the TRO is to exercise his powers and regulate his function. These are all given in Schedule 2, which are relating to attachment of property, under what circumstances the properties can be attached and it can be put to auction, who can buy it, what is the duty of the purchaser, how the money is to be appropriated after the sale, and what properties can be attached, what properties cannot be attached. These all things are given in the Schedule 2. So this Schedule 2 is basically to educate the TROs. And broadly, this is how the recoveries are to be made by the TRO. And if we talk of stay, then there is another chapter which we need to look into, that is the power of the tribunal for grant of stay. Now, the point is that the CIT appeal is not empowered under the law to grant a stay. This is very unfortunate. The AO himself, who is my assessing officer, he has been empowered under 226 to not to treat in default and pass an order. And we expect the AO to pass an order, speaking order, to say that the order he has passed is not so good so that the demand should be recovered. Well, this is something very absurd rather. Why should the AO? It should be the CIT appeal only who should, if he has the power, because the Supreme Court in the case of Muhammad Khuni case 71 ITR has said that the power of the appellate authority is ancillary and incidental to the power of appellate jurisdiction. If that is so in the case of the tribunal, then why it cannot be so in the case of CIT appeal himself? There are authorities, various case laws where they say that even a CIT appeal can grant a stay. And we do not file a stay application before the CIT appeal. I do not know why. although the law does not say so, but we can file an application before the CIT appeal, let him reject it. Because he will say that I have no power. And if he rejects it, we can go in a writ against that order. We can take a risk. We can file the application before the CIT appeal and that you have the power by quoting the case law. And if he rejects, then we can go to the High Court. Because in that event, what will happen? That if supposing the CIT appeal is not deciding my appeal for a long time, because at present I have seen there are very many appeals in which at least I have about 50 appeals with me where I have already filed my submission before COVID also. Even those appeals have not been decided and the demands are pending. And recovery is being effected by one or the other mode, by the TRO or by the AO. And in those situations, if we go to the High Court will direct the CIT to dispose of the appeal within a given period. It can be 3 months, 6 months, or whatever period the High Court will specify in the order. So that can be the advantage of filing an application before the CIT appeal. Now the point is, what is the position before the tribunal? Now 254, there was no express power earlier. When the case of Mohammed Khuni was taken up, that was in 1969. At that time, there was no express power given in the law, and the Supreme Court said that still it is an inherent power with the tribunal. And subsequently, there was a proviso added. It is not an express power given in the, but by implication, the power has been given to the tribunal under section 254. And I'll just look at the 254 also, because many times we have our appeals in the tribunal where the stay is needed. And once we are in appeal before the primary condition for filing of stay in the tribunal is that there has to be an appeal pending before the tribunal. Without my appeal pending before the tribunal, I cannot invoke the jurisdiction of the ITAT to seek stay of my disputed demand. Now it is the 254 proviso below section 2A, 254 2A. Below that, there is a proviso that the appellate tribunal may, after considering the merits of the application made by the SSC, pass an order of stay in any proceedings relating to an appeal filed under subsection 1 of 253 for a period not exceeding 180 days from the date of such order, subject to the condition that the SSC deposits not less than 20% of the amount of tax, interest, fee, penalty, or any other sum payable under the provisions of this act, or furnishes security of equal amount in respect thereof, and the appellate tribunal shall dispose of the appeal within the period of stay specified in that order. Now, earlier, there is an amendment in this section brought with effect from 1/4/2020. Now, this has been made mandatory even for the tribunal also, that it will not grant stay without asking the SSC to make payment of 20%, not less than 20%. That means that earlier there was a discretion with the tribunal to grant a blanket stay, although the tribunal never granted a blanket stay. I have not come across any case. In many of my cases also, I have sought some stay from the tribunal. They take a liberal view, of course. They do not say in terms of percentage. They will say, okay, deposit 10 lakhs, 20 lakhs, or any odd figure they will quote, you deposit this much, will grant stay for the rest of the month. Now what happens? Now the law has been so enforced. Now they have restricted the power of the tribunal also, that unless you pay 20%, the tribunal will not grant stay for the rest of the demand. But it is again harsh provision, because they have put a further condition that this stay will not operate beyond 180 days. But there is a further proviso, another proviso, which is also from 1/4/2020, that no extension of stay shall be granted by the appellate tribunal where such appeal is not so disposed of within the said period of stay as specified in the order of stay, unless the SSC makes an application and has complied with the condition referred to in the first proviso, and the appellate tribunal is satisfied that the delay in disposing of the appeal is not attributable to the SSC. So, however, that the aggregate of the period of stay originally allowed and the period of stay extended does not exceed 365 days, and the appellate tribunal shall dispose of the appeal within the period or periods of stay so extended or allowed. Problem is, the power of the tribunal has been checked here, that in aggregate, first 180 days, and it can further grant extension if there is no default on the part of the SSC, meaning thereby that if I have taken a stay from the tribunal in any case, I am not entitled to seek an adjournment. This is very cumbersome. At times it happens that if any emergency comes, for you to take adjournment in the case where a stay has been granted, the tribunal will vacate the stay. So under any circumstances in the stay granted matters, no adjournment is to be sought by the SSC. Of course, the department is free. And what happens that the departmental representatives normally seek adjournments, and by seeking repeated adjournments, the time of 180 days is lapsed. Then again, the SSC is obliged to file an application for extension. I have to move an application for further making out a case that the delay is not attributable to me or to my SSC. This is because of the departmental problem or because of the non-functioning of the tribunal or some other problems not attributable to the SSC. And in that event, the tribunal can extend the stay. But the law says that in aggregate, it cannot be beyond 365 days. Now, the point is that after 365 days means what will happen? If 365 days have gone and the tribunal has not decided my appeal, I am become a defaulter and the AO will be free or the TRO will be free to recover the whole of the amount. So this is also a very harsh provision. Although in a situation of this case also, the matter has traveled to the high courts and the high courts have taken a view that even this proviso will not fetter the power of the tribunal to grant further stay if the delay is not attributable to the assessor. Even beyond 365 days also, the tribunal can grant this stay. These are some judicial decisions, but the law does not expressly say so. And it does not provide any remedy to the SSC where because of his no fault, the stay has been vacated. Oh, yes, I feel one thing can be done, that I file a fresh application for stay, and I wonder if on my fresh application, the tribunal will still say that you pay 20% and come forward. I do not know what will be the situation, but the point is the tribunal has been also denuded of its power to grant unconditional stay or to grant blanket stay. So 20%. There is another point which is to be seen, that 20%, what is this 20% amount before the tribunal? Supposing I have made payment of 20% at the first stage before the AO when my first appeal was pending, and now I am before the tribunal. The language of the law is so worded, I believe that if I have already paid 20%, I don't need to pay another 20% when I am before the tribunal. Because the law, what is the language? Subject to the condition that the assessee deposits not less than 20% of the amount of tax, interest, fee, penalty, or any other sum payable under the provisions of this act, or furnishes security of equal amount in respect thereof. Now, it says that any amount which is payable under the provisions of this act. Now the person, supposing if somebody has not paid any tax in the earlier proceedings before the AO at the first stage when my appeal was pending before CIT appeal, my demand was say about 5 crores and I have not paid any tax. Now I go before the tribunal after my first appeal is rejected without having paid anything. Now the tribunal will say you paid 20%. Now what will be the 20% of which amount? The amount which is due under the provisions of this act. Now, there can be two interpretations. That supposing I have a demand of, say, 5 crores, and I have paid 20% at the first stage, meaning thereby that I am left with 4 crores. Now, before the tribunal can say that pay 20% of 4 crores. That means 1 crore I have already paid. Now, 20% more is to be paid. Now, in case of a person who has not paid even a penny before the AO, he still can say that I am to make only payment of 20% of the whatever amounts are outstanding as per the provision of the act. It doesn't say that the amount already paid will be reduced or will be given any benefit at this stage of tribunal. So we need to understand the implication of this provision also, because because the defaulter is going to gain before the tribunal. If anybody who has not paid anything before the AO at the first stage, then he will be better placed than a person who has been honest enough to have paid 20% earlier. Then he may have to make another 20%, meaning thereby that he has been compelled to shell off 40% of the total demand. So this is again a provision which is harsh. So we need to understand the implication of this section. And to my mind, if we have to take a benefit before the tribunal, we should not make any payment before the, let them cry or let them do whatever they can do. So this is how the tribunal can give you the stay. Now, after the stay, the appeal is decided, And supposing if I lose my appeal before the tribunal, the department will become active immediately on receipt of the order to recover the whole of the demand. Then the remedy is go in appeal before the High Court and then make out a case before the High Court for stay of demand. Then the High Court will be, seized of the matter, and on the merits of the case, then High Court will decide what to do, whether to pay partly or fully or whatever X amount or whatever decision the High Court will give. In that event, we'll have to go by the High Court's order. This is how the disputes will continue. So, in a nutshell, we have to ensure, if I say in a professional way, then that means that right from the first day when the case is taken in scrutiny, or right from the first day when we file the return, I must say, to be, honest in my professional work, that we have to be very, very sincere while discharging our duty as a professional to our client. That right from the day when he files the return, we should be very clear about the law. We should be very clear about the problems which are likely to be created in assessment if we make any false claims, if we make anything which is contrary to law. So we must advise our clients that we have to file a proper return without making any bogus claims, without any frauds, without any, whatever hanky-panky we do. So that there are less disputes in assessment. And even at the time of assessment, we must ensure that we make a proper compliance, we make a proper representation, so that the undue additions are not made, or arbitrary additions, or additions which can be deleted simply because of my non-participation of assessment. Ex parte orders are passed and huge demands are created. Most of the cases in an FAC, and presently what I'm finding, that the service of notice through electronic means, email or portal, whatever notices are received, many people are not bothered about it. Many notices have been served and nobody has responded. Ex parte orders have been passed. Now the people are coming in appeal. I have received an appeal only yesterday, addition made of about 16 crore of rupees, without any reply, without any proper compliance by the assessee. He came to me, file an appeal. I said, gentlemen, you tell me, how did you get this order? He said that this was on my portal. Then I said, then what were you doing when the notices were sent on portal? He said, it escaped my notice. Then what is the way out? How will you succeed in appeal? How will you file an additional evidence? What reasonable cost will you make out? It's not easy to plead the case before the appellate authorities in that situation. We must have a reasonable cause that we have been very attentive. No, that service, manual service is not nowhere there, no fixture. Nothing is to be proved what has been served on you. It is email, it is the SMS alert, that electronic media, your portal, any notice posted on your portal is good enough. That is a proper service. So we have to ensure that at the time of assessment, we make a proper representation. We present every possible document, evidence to avoid unnecessary additions. So if any addition is made, we must ensure that in first appeal, we make a proper representation, we make out a good case to succeed. Now it is all the more important because we are not facing anybody. We do not know who is the person in front of me who will decide my case. He may be a gentleman, he may be a very shrewd person, he may be a very intelligent person, he may be a person of an average intelligence. So we do not know. Therefore, we have to ensure that we make a very proper and a very exact, as per law, as per facts, with judicial decisions, with every possible argument we can take. In appeal, we must make out a very good case, even the tribunal, even in the first appeal, so that my appeal is, in my favor, and the demands are reduced or deleted, and I'm not unnecessarily put to any botheration. And before the tribunal also, we have to be very careful. And now there is likelihood of the tribunal also going caseless. So it will add to the working of the councils. They have to work very hard on that. So my point is that we as professionals have to be very, very honest in our working. We have to be more accurate. We have to be more updated. We have to ensure, or we have to advise our clients also to cooperate. We cannot, give the free hand to the respondent, to our clients to go and sleep. I'll take care. Many times I have seen counsel saying, "Oh, ja yaar, parwah nahi kar, assi baithe hain." No, we cannot say like that. We cannot say assi baithe hain. We have to say that if you are sleeping, you are going to suffer. We are not going to help you. I am very clear in my fundas to my clients that any client who comes to me, I make him clear that any notice which you receive, unless you come with the notice to me, I am not going to respond. So the responsibility is on you, not on me, because if we will share the responsibility, the assessee will sleep. but he will be the ultimate sufferer, and may at some end he will say that I'll shift from you to another council. But even if he goes to another council, the situation is not going to be better, because the habits of the clients have to be changed. We have to educate them to be more watchful, more clear, to avoid such situations. So this is how I feel, in a nutshell, or to sum up, that we have to handle the situations. Although we have very limited, options with us, and the departmental authorities are always on the alert. They are always on the higher side. They are always on the demonstrating situations, and they will enforce the recoveries by one or the other way. So I think broadly I have touched the issues. So now we can have some inter-house discussion or any queries or something from the Jansa. Hello. Oh, yes, ma'am.
Thank you, sir. Thank you, Basin sir. Very well done. I would say, Jera, to last we are to be honest, and the assessee must suffer if he is not honest to the department and to the government. If he has done some hanky-panky, he must suffer. We have to be very clear on that, and I think we all are with you, and we are with the department on that. If the assessee is not receiving the notices and is not responding, then I think he is to suffer, not we.
Then definitely he has to be vigilant. People who sleep over their rights, they cannot get any relief. This is really surprising. How you receive the order?
Yes.
If you receive the order, then how you can deny the notices?
Yes. That is really good. Yes.
Yes.
Situation है जी इस वेले बड़ी जबरदस्त. हाँ जी मोहित जी next please.
Yes, sir. I think we must take up the queries now.
Yes, please.
शायद
है वीडियो ऑफ है हुई है.
हाँ जी. हाँ मेरी वीडियो पे कुछ प्रॉब्लम है.
सर आप प्लीज बसीन साहब in case वीडियो ऑन कर लीजिए. I request Gulshan Badwa ji and Rajiv Sharma ji to take up the queries. We have some queries in the chat box. In case some member want to have a query, live query, then we can raise hand.
There were 82 members at a time. At one time, there were 82 members who were listening to you.
Acha, I'm so grateful. I think it's a reasonable number of people.
Yes, sir.
So,
Basin साहब, thank you very much.
Yes, please.
आज का जो डिस्कशन है, I think so, इतना elaborative discussion.
Gulshan ji, एक मिनट.
जी.
Basin sahab, we have a study circle team which is handling all the study circle. This is one of the study circle activity. Mr. Rajiv Kaushal is our convener of the study circle.
Yes,
and Mr. Gulshan Badwa is one of the leading members. He's a co-convener, I would say. And Mr. Pushkar is there. He is absent today. He was to go somewhere. And Mr. This Sangam and Anshul and one more.
Rajiv Sharma ji.
Rajiv Sharma is also member of this study circle team. They have done so wonderfully good. And today's seminar webinar is also by that team only. So I would request now Mr. Gulshan Badwa and Mr. Rajiv Sharma of the statistical team to raise the query on behalf of the members. Please.
Thank you, sir.
I'll try to. I will try to. Please.
I think इतना elaborate discussion आज तक इस topic पे हुआ नहीं. So from different angles we have able to learn so many dimensions of this topic. So there are the first query is with from Mr. I.S. Kurana ji. That is, what should be done when high pitch demand is apparently wrong and the documents relied upon by the AO are non-existent. And in those cases, what needs to be done, because apparently the demand is wrong. So what is whether the same process is to be adopted or some other relief can be obtained?
See, again, the point is that high pitched assessment. It's a case of a high pitched assessment, and whether it is on facts or on law, that has to be seen. If it is purely on facts, then what is the evidence? Whether it is in my favor or it is in the department's favor. If the evidence is in my favor and it has not been considered by the AO, or it has been rejected without any judicial reasoning, a process of reasoning has to be elaborated by the AO while making an assessment. And if it is a non-speaking order, definitely we have to spell out everything in the stay application. If the demand is very high, then I believe that we have to make out a good case again before the AO. And if AO rejects it, then definitely the only remedy is writ in the high.
Mohit ji, kindly unmute Khurana ji. I think if any further observation is over there.
Yes, sir.
Unmute karo.
Khurana ji, kindly unmute कर लीजिए.
Kindly unmute.
Khurana ji,
yes.
Point is the same that you make out your case before the AO. If the AO is not in agreement, then move before the CIT or the principal CIT for a review of the rejection of the AO. And if the CIT is also not convinced, you make out a proper case. If the evidence is very, very clear in my favor, then AO is very arbitrary in the rejection of the evidence. Then let the CIT also give a finding on that. And in that event, if the demand is so big that you cannot, and if it is going to put you into undue trouble, then better go to the High Court. There's no choice. If the demand is very heavy, unless you are able to dodge the department, for how long? If the department is sleeping, then it's okay. But if the department is strict and they enforce the recovery by some measure which is a problem, then go to the High Court.
Sure. It's okay.
Yes, please.
Gulshan ji, please take the next query.
Gulshan ji, unmute yourself.
Gulshan ji, please.
Request Jain साहब to, I think it's his query. तो Jain साहब आप अपनी query एक बार देखिए.
In case there is a stay of demand by the AO or by the CIT, will the interest liability continue?
Interest will continue irrespective of the stay granted or not granted. Under all circumstances, the interest will continue unless the demand is nullified. If the demand is deleted in appeal, then the interest will also go. But if the stay has been granted, then it can never be with the condition that 222 interest will not come into force. It will in all situations be there. It is mandatory. It has to run.
Sir, the next query is from Jaspinder Singh ji, and what is saying that whether notice received on email, which is of the professional, be treated as a service of notice on assessee's last known address, whether it is treated as a valid service. And the second question is what to do if professional is not in touch with that assessee.
You see, this has to be seen in the context of the service of notice under section 282(1). If we refer to section 282(1), then clause C says that the service of notice or summon or requisition or order or any other communication under this act may be made by delivery or transmitting a copy thereof to the person therein named in the form of any electronic record as provided in Chapter 4 of the Information and Technology Act 2000, or by any other means of transmission of documents as provided by the rules made by the board in this behalf. So the point is that the physical service of notices is no more required. Now
Correct.
It is the profile in the portal, in my registered profile, whatever email address and whatever phone number I have given. If the information is transmitted, notice or whatever is transmitted on that email or on that address, then of course it is for the assessee to prove that it is not a good service. The department will say it is a good service. So if we say that my email or the email of my professional is not in my registered profile, only then I can raise this objection. If I have changed my counsel, if there is any change in my in many cases, the people have given the mail addresses of their relatives, of their friends, of somebody, so casually they gave it. So that is why the Aadhaar and PAN phone number have been interlinked. That is the reason. So because these laws of Chapter 4 of the Information and Technology Act is very, very clear. We need to study this act also for the purpose of service of notice. Because if these modes have been adopted by the department, then I have no case to make out of non-service of. So if mail address of a previous consul is there, but he is now with the new consul, then it should be immediately changed on my income tax profile, whatever has been registered. That has to be ensured by the professional, because the assessors are not very particular about it. We need to educate them also.
Correct, sir. मोहित जी, आगे चैट बॉक्स में तो और क्वेरीज नहीं है. आई थिंक फ्रॉम ऑल द मेंबर्स में भी आस्क्ड.
जैन साहब कुछ कहना चाहते हैं सर?
हाँ जी.
Regulation also, if at all any stay application should be filed at the first place.
You see, there is no requirement given in the law that you have to file an application first day. There is no requirement.
Okay.
Now, if we refer to the 220(6), that is the only law, that is the only provision which says, I'll just read out once again, because it is very interesting question. Just look at the language of the law, which in the Supreme Court decision was said to be a very cryptic language. So if we look at 220(6), the language is where an assessee has presented an appeal under 246. Now the first condition is that I'm presenting my appeal before the CITPL. The AO may, in his discretion and subject to such conditions as he may think fit to impose in the circumstances of the case, treat the assessee as not being in default in dispute in the appeal, even though the time for payment has expired, as long as such appeal remains disposed of. It doesn't talk that on an application to be made by the assessee. See the language of the law. Even the AO himself can treat you as an assessee in default or not in default. Well, it doesn't require that you have to present he says that present an appeal before the appellate authority, and then the AO will treat you this way. But it doesn't say that you have to simultaneously file an application before the AO. It doesn't say so. It is only as a precaution that we have filed an appeal, so we write an application to the AO that since now we have filed an appeal, because the AO may not be aware that I have filed an appeal. There may be cases, because it happens so that in many cases the appeals are delayed. There are people who come to file appeal after so many years. Many cases where the years have gone. 2 साल 4 साल तक appeal filing हुई है. I have a case where after 10 years I have filed an appeal. So the AO will not, go by your application. If you have presented an appeal, then you file an application before the AO, and then AO will come to know of it, and then he will go. Otherwise, what he will do? He will say that 30 days have gone. I'm going to attach your accounts. So therefore, there comes a requirement to file an application by implication, not by the requirement of law. The language is very clear. It is not so.
सर जगाने वाली गल हो जाएगी ना.
नहीं एक चीज है. नहीं, there is one. Kindly see subsection 3. On the contrary, I have referred to subsection 3, which we hardly ever refer. Now let me read out subsection 3 for your interest. Without, this is also in section 220, subsection 3. 6 में तो provision आ गया ना कि उसकी discretion में क्या-क्या, where I file an appeal. Now 3 says without prejudice to the provisions contained in subsection 2. Now subsection 2 means if the amount specified in the notice of demand is not paid within the period limited under subsection 1, the assessee shall be liable to pay simple interest. So without prejudice to interest, आपका पहला क्वेश्चन था कि इंटरेस्ट चलेगा कि नहीं, तो इंटरेस्ट तो चलेगा. तो 3 में क्या कर रहा है कि without prejudice to the provisions contained in subsection 2 on an application made by the assessee. Here the requirement of application comes up. Before the expiry of the due date under subsection 1, the AO may extend the time for payment or allow payment by installments subject to such conditions as he may think fit to impose in the circumstances of the case. It doesn't talk of appeal. And it says that you have to file an application before the expiry of the due date. Means कि 30 days से पहले ही application file होनी चाहिए. This does not require a filing of appeal. This subsection 6 says where an appeal is presented, then AO may not treat you in default for reasons or for whatever conditions he is going to impose. But subsection 3 says that where you make an application. So the law has been so drafted. Here it doesn't say that you have to file an application. but we must file an application. Otherwise, otherwise the same thing will come. If a notice under 148 is issued and he says that I have recorded a satisfaction, where is that satisfaction? So there has to be something on record to show that some action has been initiated by me to seek the stay of demand, which the AO has rejected. Because if you will not file an application, then the rejection will not come up. If the rejection will not come up, further action will not come up. We cannot go to the High Court. We cannot go to any further authority. So in any case, we have to move an application.
In any case, it can be filed after beyond 30 days also.
There is no limitation.
There is no limit. 226.
What I normally don't file it.
Yeah.
I don't file. I'm not quick in filing stay application because one वो जड़ी गल तुसी होंगे ना जुगाड़ वाली गल आ. What is right in Punjabi? In Punjabi, we can say, supposing now I have a case in appeal where a demand of rupees 4 crores odd is there. Now the assessee says, "Yaar, file an application first." मैं कहता तन्नू की है यार, तू जा कर नो. I will file it whenever I will feel it fit.
Yes.
वो कहता क्यों जी? मैं कहा जी मैं आज ही कहता ना उन्हें आज ही कहना 20% जमा करा, करोड़ रुपया लेके आ, मैं जमा करा के तेरी स्टे लवा देना. वो कहता नहीं जी मेरे को पैसे नहीं है. मैं कहा जस्ट हो जा फिर. Forget it. Because he cannot attach my account without a notice. Once he gives me a notice, I will immediately file a stay application. Then he will be bound to consider it because the law doesn't say that I have to file my stay application within 30 days or after 30 days. Look at the law. The language is clear. Subsection 3 doesn't talk of appeal. Subsection 6 talks of appeal. And once I have filed an appeal, if my appeal is late, supposing if my appeal is after 2 years, how can I file my stay early? I cannot. I may choose not to file an appeal at one point of time, and I may choose to file it after some time. Maybe a change in circumstance, maybe change in my thought process, maybe a different advice given by a different counsel. कि यार आपको appeal करनी चाहिए थी, क्यों नहीं की? Then I go for an appeal. Therefore, where I present an appeal, only then it becomes my responsibility to file an application. But there is no limitation given that I have to file it within 30 days, beyond 30 days, beyond 60 days, beyond what point of time. As much time I can gain from the AO, as long as the AO sleeps over the matter, I think we should avoid it. We can file it subsequently.
In one of my case, he has determined that under section 245, I will adjust your refund. 31 March ਨੂੰ order ਹੋਇਆ ਜੀ 148 ਦਾ ਤੇ 147 ਦਾ ਤੇ ਹੁਣ ਉਹ 7000 ਤਰੀਕ ਨੂੰ ਮੈਨੂੰ ਲੈਟਰ ਆ ਗਿਆ CPC ਤੋਂ ਕਿ ਮੈਂ ਤੁਹਾਡਾ refund adjust ਕਰਨਾ section under section 245.
Yes, they can do it. Yes, here see, it is for the AO to be prompt. If the AO is prompt, we have to be prompt. If the AO is active, we cannot sleep. So if the NFAC is active enough, because you see, this is all artificial intelligence. Now the things are not in our hands.
ਇੱਕ ਤਰੀਕਾ ਹੋਰ ਵੀ ਸਰ 154 ਦੀ ਐਪਲੀਕੇਸ਼ਨ ਪਾਤੀ ਜਾਵੇ
ਜੀ
ਅਗਰ 154 ਦੀ ਕੋਈ ਐਪਲੀਕੇਸ਼ਨ ਬੰਦੀ ਹੋਵੇ ਉਹ ਪਾਤੀ ਜਾਵੇ ਤਾਂ ਉਹ ਫਿਰ ਡਿਮਾਂਡ ਆਈ ਥਿੰਕ ਇਟ ਕੈਨ
ਨਹੀਂ there is a weight in your contention that once I file 154 then I say that my demand is disputed.
Yeah.
Then it has to be. Now what happens in one of my cases, I remember it was somewhere in 99 or 2000. I filed one rectification application before the AO and the TRO issued attachment notice. And the commissioner at Jalandhar at that time was one Mr. Gupta. He was very strict officer, very strict officer. And the TRO attached my accounts. I went to the additional commissioner. I told him, I said, sir, your attachment is invalid. He said, why? I said, my 154 is pending. Then he said, where is your 154? I said, this is with my AO. And how come the TRO knows it? Then I said, sir, there is an order of the commissioner that the TRO has concurrent jurisdiction with the AO in the matter of recovery. Then he has to get a clearance from the AO that there is no pendency of rectification or any other such application of the SSC, which has the impact of reducing my demand. Then I went to the CIT and told him that this has been done by your TRO with the consent of the immediate senior officer, and this is bad in law. This is against your orders. You said that there is a concurrent jurisdiction of the TRO with the AO. Then why can't the TRO deal with my 154? And then he was with me. He called that senior officer. He said, listen to what Mr. Basin is saying and look at the order which I had passed. I cannot deny this order. This order says that he has a concurrent jurisdiction. What does it mean? Then he withdrew that notice, and then he asked the AO to deal with my rectification first and then give another certificate to the TRO. for the demand which is due. And then that amount was brought down by rectification, and the whatever leftover demand was there, then that was given to me, and then I arranged some payment against that demand. You have a point that 154, if it is pending, we can always impress upon the AO to first deal with that and then to come out with the recovery, because that's a dispute that has to be settled, because law applies, gives 6 months time for dealing with the rectification application, and if it is not dealt with, then there is a deeming provision that it has been accepted.
Yes, good. Thank you.
सर बसीन साहब, मोहित जी, एक क्वेरी मेरी है
जी।
सर, इसमें कई केसेस में क्या है कि डिपार्टमेंट की तरफ से पुरानी डिमांड सीपीसी पर अपलोड की हुई है, से 2010, 11, 12, और अभी क्या हो रहा है कि वो पुरानी डिमांड्स ना तो कभी कम्युनिकेट की गई हैं, तो अभी जो किसी का रिफंड बनता है तो उसमें से वो एडजस्ट कर रहे हैं। सो ऐसे केसेस में जहां पर डिमांड्स आर आउटस्टैंडिंग फॉर मोर देन 10-12 इयर्स, तो ऐसे केसेस में क्या किया जाना चाहिए सर?
You see, the demand which is outstanding in the portal of the department, that will be automatically recovered now. This is very serious problem.
Yes, sir.
Unless we say that demand is not recoverable. If that demand is lawfully recoverable, we just cannot deny it.
Correct.
If you say that the demand is no more, recoverable because of any appeal effect,
Yes,
or for some other reason, good reason, that this is deleted, then only we can write to the commissioner, we can write to the AO, we can write to the CPC, we can write to the board also, or we can file a grievance application also. Whatever channels are open, we can apply everywhere to delete that demand if it is lawfully not recoverable. Simply by lapse of time, we cannot say that it is no more recoverable.
but in any case, the time for 154 has already been elapsed.
You
So,
see, the problem is that if 154 is pending, then we can also seek the rectification to be disposed of. Although the law provides for 6 months, but it doesn't say that after 6 months, what will be the consequence. There are some decisions of the tribunals which say that after 154, it will be deemed to have been allowed, but that is not acceptable everywhere, anywhere. That is something to be said by the judicial authorities. But the AOs by the department or the law as such does not say anything. So therefore, the 154, if it is pending, and because of that 154, we say that my demand is not recoverable, then we must get that 154 settled at the earliest. Because we cannot file 154 at any point of time. It has to be filed within a given time. If we have filed it within a given time and it has not been disposed of, we have evidence of that, then we must seek disposal of it. We may file a petition, grievance petition somewhere to seek disposal of our rectification if that rectification is going to result into cancellation of that demand. But unless the demand is lawfully cancelled, that will always remain there on the portal unless it is written off by the department.
correct.
Written off. There is a provision of writing off the policy.
Thank you, sir.
So we have to be vigilant about that also.
मोहित जी, जतिंदर जी कुछ पूछना चाहते हैं?
हाँ जी, हाँ जी,
ਜੋ ਜਿਹੜਾ ਗੁਲਸ਼ਨ ਜੀ ਨੇ ਸਵਾਲ ਕੀਤਾ ਨਾ ਜੀ,
हाँ जी,
ਕੀ ਹੋਇਆ, ਕਾਫੀ ਸਾਰੇ ਡਿਮਾਂਡ ਜੈਸੇ ਅਸੀਂ ਜਦੋਂ ਇੱਕ ਸੀਪੀਸੀ ਨੂੰ ਹੋਇਆ ਨਾ ਜੀ ਕੰਮ, ਫਿਜ਼ੀਕਲ ਤੋਂ ਸੀਪੀਸੀ ਚ ਗਿਆ
जी जी जी
ਡਿਮਾਂਡ ਜਿਹਨਾਂ ਨੇ ਇਹ ਏਓਜ਼ ਨੇ ਆਪਣੇ ਵੈਸੇ ਹੀ ਅਪਲੋਡ ਕਰਤੀਆਂ, ਜਿਹੜੇ ਕਿ ਅਪੀਲ ਜ਼ੀਰੋ ਹੋ ਚੁੱਕੀ ਹੈ, ਡਿਲੀਟ ਹੋ ਚੁੱਕੀ ਆ, ਲੇਕਿਨ ਰਿਕਵਰੀ ਰਜਿਸਟਰ ਖਤਮ ਨਹੀਂ ਹੋਈਆਂ ਤਾਂ ਅਪਲੋਡ ਹੋ ਗਈਆਂ, ਉਹ ਹੁਣ ਖਤਮ ਨਹੀਂ ਹੋਣ ਜਾਂਦੀਆਂ। ਉਹ ਤਾਂ
वो पता क्या है, एक प्रॉब्लम हैगी है, there is a portal problem also, there is a problem on the level of AOs also because of the restructuring of the department, the faceless system. Many records are not available. A have problem. I know I am also facing similar problems in my case also.
Yes.
I have problems. I am facing similar problems. ਇਹ ਤਾਂ ਛੱਡੋ ਤੁਸੀਂ, ਮੈਂ ਹੁਣ ਅੱਜ ਦੀ ਡੇਟ ਦੇ ਵਿੱਚ ਮੇਰਾ ਇੱਕ ਕਲਾਇੰਟ ਹੈ ਜਿਹੜੇ VSV ਦੇ ਵਿੱਚ ਉਹਦਾ ਘੱਟੋ ਘੱਟ 32 ਲੱਖ ਦਾ ਰਿਫੰਡ ਹੈ। VSV ਦੇ ਵਿੱਚ 32 ਲੱਖ ਦਾ
ਅਨਮਿਊਟ ਕਰ ਲਓ ਸਰ।
gone, and that refund is not met the principal CIT, and I gave in writing. One madam is here. I said, madam, my refund under VSV is due. You are not paying me any interest on that amount. How? What right you have to hold it? He called the AO and checked up the matter. He says, "Ki I have already issued a refund from here. and I am not getting, I am unable to cancel that in the computer. So there is a portal problem. Then I told that CAT, okay, madam, I am not going to wait for indefinite period. Take a quick action. Otherwise, I will see what action I will take. Today, I got a call from the SSC that no, nothing. At that time, she said, okay, wait up to 31st March, we will take some action. Now, today is 22nd April, no action has been taken. Now, I have advised the SSC, please get ready, we will file a writ in the High Court because they are keeping my money illegal in an illegal way. They have no right to hold my money. More so when they are not paying any interest on that amount. So we will seek interest also from the High Court. Well, these are the problems because of the portal also, and some technical faults are there.
Yes, sir. Jitinder Machog wants to ask a question. Mohiji, please unmute him.
Jitinder ji, please ask your query.
सर मेरा एक केस थी 2014-15 10 में सेक्सी का पार्टनरशिप फर्म से सर उन्होंने तो
Sir,
पहला
I'm not
उन्होंने
able to hear you. Please थोड़ी ना इको कर रही है आवाज थोड़ी. हेलो.
ठीक है सर आवाज आ रही है
पीछे ना कोई बैकग्राउंड आवाज भी आ रही है ना.
सर मोहित साहब को म्यूट कर दो.
Sir, all are already muted.
Please.
जी सर मेरा एक क्वेरी थी सर मेरे 2014-15 में केस आया और पार्टनरशिप फर्म का केस आया सर तो पहला जेडे उन्होंने नोटिस किया 148 दा एंड 142 वाटे नोटिस करे
Sir, I am still not able to hear you.
जितेंद्र जी आपके यहाँ ना प्रॉब्लम है कोई उसमें जा
मतलब कोई
वॉइस
sound
का इशू आ रहा है.
आवाज आ रही ठीक सर?
हाँ जी.
यस इट इज ऑडिबल.
हाँ
अब
प्लीज.
ठीक है.
हाँ बोलिए.
जी सर मैं कह रहा ਸੀ ਕਿ ਸਰ ਇੱਕ ਮੇਰਾ ਕੇਸ ਹੀ ਪਾਰਟਨਰਸ਼ਿਪ ਫਰਮ ਦਾ ਅਸੈਸਮੈਂਟ ਇਹ 2014-15
ਜੀ.
ਸਰ ਉਸ ਦੇ ਵਿੱਚ ਪਹਿਲਾਂ 148 ਦਾ ਨੋਟਿਸ ਆਇਆ ਲਾਸਟ ਈਅਰ 2021 ਦੇ ਵਿੱਚ ਮਾਰਚ ਵਿੱਚ ਉਹਦੀ ਰਿਟਰਨ ਫਾਈਲ ਕਰਨੀ 148 ਦੇ ਅੰਦਰ ਉਹ ਰਿਟਰਨ ਫਾਈਲ ਨਹੀਂ ਕੀਤੀ ਸਰ. ਉਸ ਤੋਂ ਬਾਅਦ 142(1) ਦੇ ਨੋਟਿਸਿਸ ਆਏ ਜੁਲਾਈ ਦੇ ਵਿੱਚ ਆਇਆ ਸੀ ਦਸੰਬਰ ਚ ਆਇਆ ਸਰ ਜਨਵਰੀ ਚ ਆਇਆ ਬਟ ਉਹ ਸਰ ਉਹਦੇ ਅਗੇਂਸਟ ਪੁਰਾਣੇ ਸੀ ਦੇ ਕੋਲ ਮੇਲ ਚ ਸਾਰੇ ਨੋਟਿਸਿਸ ਗਏ ਉਹਦੀ ਰਿਟਰਨ ਫਾਈਲ ਨਹੀਂ ਕੀਤੀ ਸਰ ਉਹਨਾਂ ਦੀ. ਸੋ ਉਸ ਤੋਂ ਬਾਅਦ ਸਰ ਇਹਨਾਂ ਦਾ ਸਰ ਇਹਨਾਂ ਨੂੰ 144 ਦੇ ਲਈ ਅਸੈਸਮੈਂਟ ਸਮੂਹ ਮੋਟੋ ਉਹਨਾਂ ਨੇ ਰੇਜ਼ ਕਰ ਦਿੱਤੀ ਸਰ ਔਰ ਉਸ ਤੋਂ ਬਾਅਦ ਉਹਦਾ ਟਾਈਮ ਵੀ ਨਿਕਲ ਗਿਆ ਸਰ ਔਰ ਟਾਈਮ ਨਿਕਲਣ ਤੋਂ ਬਾਅਦ ਵਿੱਚ ਸਰ ਉਹਨਾਂ ਦੇ ਇੱਕ ਉਸ ਤੋਂ ਬਾਅਦ ਸਰ ਮੇਰੇ ਕੋਲ ਆਏ ਔਰ ਉਹਦਾ ਆਪਾਂ ਟਾਈਮ ਲੈ ਕੇ ਇੱਕ ਉਹਦਾ ਰਿਪਲਾਈ ਫਾਈਲ ਕਰਦਾ ਰਿਪਲਾਈ ਸੀ ਉਹਨਾਂ ਦਾ ਕਿ ਉਹਨਾਂ ਨੇ 5 ਕਰੋੜ ਦਾ ਕਹਿ ਰਹੇ ਤੁਸੀਂ ਕੈਸ਼ ਜਮ੍ਹਾਂ ਕਰਾਇਆ ਬੈਂਕ ਦੇ ਵਿੱਚ ਉਹ ਸਰ ਸਾਰਾ ਜਸਟੀਫਾਈ ਕਰ ਦਿੱਤਾ ਸੀ ਵੀ ਇਹ ਨਾਰਮਲ ਕੋਰਸ ਆਫ ਬਿਜ਼ਨਸ ਦੇ ਵਿੱਚ ਆਇਆ ਐਂਡ ਉਹਨਾਂ ਨੇ 144 ਦੇ ਅਸੈਸਮੈਂਟ ਆਰਡਰ ਦੇ ਵਿੱਚ ਉਹਨੂੰ ਐਕਸੈਪਟ ਕਰ ਲਿਆ ਸਰ ਸਾਰਾ ਐਂਡ ਸਰ ਉਹਨਾਂ ਨੇ ਬਾਅਦ ਵਿੱਚ ਇਸ ਚੀਜ਼ ਨੂੰ ਡਿਨਾਈ ਕਰਤਾ ਕਿ ਤੁਸੀਂ ਸਾਡੇ 148 ਦੇ ਨੋਟਿਸ ਦਾ ਰਿਪਲਾਈ ਨਹੀਂ ਕੀਤਾ 142(1) ਦਾ ਤੁਸੀਂ ਰਿਪਲਾਈ ਨਹੀਂ ਕੀਤਾ ਅਸੀਂ ਸਾਰੀ ਗੱਲਾਂ ਮੰਨਦੇ ਹੈਗੇ ਬਟ ਜਿਹੜੀ ਅਸੈਸਮੈਂਟ ਹੈਗੀ ਅਸੀਂ 184(5) ਜਿਹਦੇ ਵਿੱਚ ਕੀ ਸਰ ਉਹਨਾਂ ਨੇ ਕਿਹਾ ਕਿ ਅਸੀਂ ਤੁਹਾਡੀ ਐਜ਼ ਜਿਹੜੀ ਅਸੈਸਮੈਂਟ ਐਜ਼ ਪਾਰਟਨਰਸ਼ਿਪ ਫਰਮ ਨਹੀਂ ਕਰਨੀ ਉਹ ਅਸੀਂ ਐਜ਼ ਤੁਹਾਡੀ ਜਿਹੜੀ ਅਸੈਸਮੈਂਟ ਹੈ ਅਸੀਂ EOP ਕਰਾਂਗੇ ਉਹ ਤੁਹਾਡੇ ਵਿੱਚ ਸਰ ਉਹਨਾਂ ਸੈਲਰੀ ਪੇ ਟੂ ਪਾਰਟਨਰਸ ਐਂਡ ਰੈਮੂਨੇਸ਼ਨ ਐਂਡ ਇੰਟਰਸਟ ਟੂ ਪੇ ਟੂ ਪਾਰਟਨਰਸ ਸੋ ਸਾਰੀ ਉਹਦੀ ਐਡੀਸ਼ਨ ਕਰ ਦਿੱਤੀ ਸਰ 69,000 ਦੀ ਨੈਟ ਟੈਕਸੇਬਲ ਇਨਕਮ ਹੈਗੀ ਸੀ ਐਜ਼ ਪਰ ਬੈਲੈਂਸ ਸ਼ੀਟ ਉਸ ਦੇ ਵਿੱਚ 8 ਲੱਖ ਰੁਪਏ ਦਾ ਉਹਨਾਂ ਨੇ ਰੈਮੂਨੇਸ਼ਨ ਐਂਡ ਇੰਟਰਸਟ ਪੇ ਟੂ ਪਾਰਟਨਰਸ ਉਹ ਐਡ ਬੈਕ ਕਰਕੇ ਸਭ 2.5 ਲੱਖ ਦਾ ਇੰਟਰਸਟ ਟੈਕਸ ਬਣਾ ਕੇ ਬਾਕੀ 2.5 ਲੱਖ ਦੀ ਇੰਟਰਸਟ ਪੈਨਲਟੀਜ਼ ਪਾ ਕੇ 5 ਲੱਖ ਦੀ ਡਿਮਾਂਡ ਕਰ ਦਿੱਤੀ ਸਰ ਸਰ ਇਸ ਕੇਸ ਦੇ ਵਿੱਚ ਉਹ ਨੈਕਸਟ ਕੀ ਕੋਰਸ ਆਫ ਐਕਸ਼ਨ ਕਰਨਾ ਸਰ ਉਹਦੇ ਮੈਂ ਸਰ ਇਹ ਜੈਨ ਸਾਹਿਬ ਨੂੰ ਵੀ ਭੇਜਿਆ ਸੀ
ਉਹਨਾਂ ਨੇ ਤੁਹਾਨੂੰ AOP ਦਾ ਨੋਟਿਸ ਦਿੱਤਾ ਸੀ ਕਿ you will be assessed as an AOP. Have they given you a notice that they want to assess you as an AOP?
ਹਾਂਜੀ ਸਰ ਉਹਨਾਂ ਨੇ ਫਾਈਨਲ ਅਸੈਸਮੈਂਟ ਕਲੋਜ਼ ਕਰ ਦਿੱਤੀ 29 ਮਾਰਚ ਨੂੰ ਜਿਹਦੇ ਵਿੱਚ ਫਾਈਨਲ ਅਸੈਸਮੈਂਟ ਆਰਡਰ ਜਿਹੜਾ ਉਹਨਾਂ ਨੇ ਭੇਜ ਦਿੱਤਾ ਸਾਨੂੰ 144 ਦੇ ਅੰਦਰ ਰੀਡ ਵਿਦ ਸੈਕਸ਼ਨ 144B
ਨਹੀਂ ਉਹ ਨਹੀਂ ਹੈਲੋ
आ गया आपकी बात
जितेंद्र जी आप म्यूट हो गए हो.
हेलो
एंड रीड विद सेक्शन 144B
ਨਹੀਂ
ਜਤਿੰਦਰ ਜੀ
ਅਸੈਸਮੈਂਟ
ਆਰਡਰ ਆਪਣੇ ਕੋਲ ਆ ਚੁੱਕਾ ਹੈ
ਜਤਿੰਦਰ ਜੀ ਕੁਐਸਚਨ ਇਹ ਆ ਕਿ ਜਦੋਂ ਉਹਨਾਂ ਨੇ ਤੁਹਾਨੂੰ AOP ਟ੍ਰੀਟ ਕੀਤਾ ਕਿਆ ਉਹਨਾਂ ਨੇ AOP ਕਰਨ ਤੋਂ ਪਹਿਲਾਂ ਤੁਹਾਨੂੰ ਕੋਈ ਨੋਟਿਸ ਦਿੱਤਾ ਸੀ ਵੀ ਤੁਹਾਨੂੰ PF ਨਹੀਂ ਕਰਾਂਗੇ ਫਰਮ ਨਹੀਂ ਰੱਖਾਂਗੇ ਤੁਹਾਨੂੰ AOP ਟ੍ਰੀਟ ਕਰਾਂਗੇ ਇਹ ਪੁੱਛ ਰਹੇ ਆ ਬਸੀਨ ਸਾਹਿਬ
हेलो सर आवाज आ रही
जी
जी सर
बोले ਮੈਂ
ਸਰ
ਇਹ ਪੁੱਛ ਰਿਹਾ ਸੀ ਕਿ ਉਹਨਾਂ
ਆਪਣੀ
ਨੇ
ਸਰ ਲਾਸਟ ਡੇਟ ਹੈਗੀ 28 ਅਪ੍ਰੈਲ, ਜਿਹਦੇ ਵਿੱਚ ਆਪਾਂ 1 ਮੰਥ ਦਾ ਆਪਾਂ ਨੂੰ 30 ਡੇਜ਼ ਦਾ ਟਾਈਮ ਦਿੱਤਾ ਸੀ ਉਹਨਾਂ ਨੇ, ਨੋਟਿਸ ਆਫ ਡਿਮਾਂਡ ਦਿੱਤਾ ਐਂਡ ਉਹਦੇ ਵਿੱਚ 144 ਦਾ
ਫਾਈਨਲ ਆਰਡਰ ਆ ਗਿਆ ਨਾ। 30 ਡੇਜ਼ ਦਾ ਨੋਟਿਸ ਆਫ ਡਿਮਾਂਡ ਮੀਨਸ ਕਿ ਫਾਈਨਲ ਆਰਡਰ ਆ ਗਿਆ ਤੁਹਾਡੇ ਕੋਲ। ਮਾਈ ਪੁਆਇੰਟ ਇਸ ਕਿ ਕਿਆ ਉਹਨਾਂ ਨੇ ਕੋਈ ਤੁਹਾਨੂੰ ਸ਼ੋਕਾਜ਼ ਨੋਟਿਸ ਦਿੱਤਾ ਸੀ ਕਿ ਤੁਹਾਡੀ ਅਸੀਂ AOP ਦੀ ਅਸੈਸਮੈਂਟ ਕਰਨ ਲੱਗੇ ਆ? ਕੋਈ ਐਸਾ ਨੋਟਿਸ ਤੁਹਾਨੂੰ ਦਿੱਤਾ ਉਹਨਾਂ ਨੇ ਪਹਿਲਾਂ? ਕਿਉਂਕਿ ਨੋਟਿਸ 148 ਵਾਸ ਇਸ਼ੂਡ ਇਨ ਦੀ ਨੇਮ ਆਫ ਦੀ ਫਰਮ। ਤੁਸੀਂ ਇਹੀ ਕਹਿ ਰਹੇ ਹੋ ਨਾ, 148 ਵਾਸ ਇਸ਼ੂਡ ਇਨ ਦੀ ਨੇਮ ਆਫ ਫਰਮ ਐਂਡ ਨਾਟ ਇਨ ਦੀ ਨੇਮ ਆਫ AOP। ਠੀਕ ਹੈ
ਜੀ
ਨਾ?
ਸਰ, ਇਟ ਇਜ਼ 147 ਦੀ ਵਿੱਚ ਜਿਹੜੀ ਅਸੈਸਮੈਂਟ ਕੀਤੀ, ਇਟ ਇਜ਼ ਇਨ ਦ ਨੇਮ ਆਫ ਫਰਮ ਸਰ।
ਤੇ AOP ਕਿਸ ਤਰ੍ਹਾਂ ਬਣਿਆ ਫਿਰ? ਅੱਛਾ, ਅਸੈਸਮੈਂਟ ਫਾਈਨਲੀ AOP ਚ ਕੀਤੀ ਉਹਨਾਂ ਨੇ?
ਸਰ ਹਾਂਜੀ, ਉਹ ਸਰ ਇਹਨਾਂ ਨੇ ਸੈਕਸ਼ਨ 184(5) ਇਨਵੋਕ ਕਰ ਦਿੱਤਾ। ਮੈਂ ਉਸ ਨੂੰ ਉਹਦੇ
हाँ
ਸਟੱਡੀ
नहीं,
ਕੀਤਾ।
देखो 184(5) देखो 184(5) section says that if there is any default on the part of the assessee as mentioned in section 144, मतलब अगर तुसी non compliance है तो you can be of course denied the benefit of the salary and remuneration or whatever to the partner। वो law दे विच हैगा है, that is a lawful action, because in the case of a partnership firm ये provision है कि जे तुसी compliance नहीं करोगे तो ਤੁਹਾਨੂੰ ਉਹਨਾਂ ਨੇ AOP treat करके आ सारे allowances ਜਿਹੜੇ ਤੁਸੀਂ benefits ਲਏ you can be disallowed। Now you have to make out a case that there is no default under 144 on your part। Is it so?
But sir, to my mind, ਇਹਨਾਂ ਨੂੰ ਡਰਾਫਟ ਅਸੈਸਮੈਂਟ ਆਰਡਰ ਆਇਆ ਹੋਏਗਾ ਪਹਿਲਾਂ ਸ਼ੋਕਾਜ਼ ਨੋਟਿਸ ਤੇ।
ਉਹੀ ਮੈਂ ਪੁੱਛ ਰਿਹਾ ਨਾ ਕਿ ਇਹਨਾਂ ਨੂੰ ਸ਼ੋਕਾਜ਼ ਨੋਟਿਸ
ਜ਼ਰੂਰ ਆਇਆ ਹੋਏਗਾ, ਇਹਨਾਂ ਨੇ ਗੌਰ ਨਹੀਂ ਕੀਤਾ।
ਇਹਨੇ ਗੌਰ ਨਹੀਂ ਕੀਤਾ, ਦੇਖਿਆ ਨਹੀਂ ਆ, ਕੁਐਸਚਨ ਕਰਦੇ ਪਏ।
मतलब they should have made out a case of
relevant
हाँ नहीं, ये देखो इसलिए मैं कह रहा हूँ कि साडी compliances ਸਾਨੂੰ problem ਚ ਲਿਆਂਦੀਆਂ ਨੇ। If we don't comply properly, if you don't comply at all, then definitely you are put into मतलब indefinite problems।
ਕਿ ਫੇਸਲੈਸ ਅਸੈਸਮੈਂਟ ਚ ਬੜਾ ਕਲੀਅਰ ਹੈਗਾ, ਅਗਰ ਕੋਈ ਡਿਪਾਰਟਮੈਂਟ ਨੇ ਐਡੀਸ਼ਨ ਕਰਨੀ ਹੈ ਤਾਂ ਉਸ ਦਾ ਉਹਨੂੰ ਫਾਈਨਲ ਸ਼ੋਕਾਜ਼ ਨੋਟਿਸ ਦੇਣਾ ਪੈਣਾ ਹੈ, ਐਵੇਂ ਉਹ ਕਰ ਹੀ ਨਹੀਂ ਸਕਦਾ।
ਬਿਲਕੁਲ ਠੀਕ ਹੈ ਜੀ। ਦੇਖੋ
ਡੈਫੀਨੇਟ ਇਹਨਾਂ ਨੂੰ ਆਇਆ ਹੋਏਗਾ ਸ਼ੋਕਾਜ਼ ਨੋਟਿਸ ਪਹਿਲਾਂ ਕਿ ਦਿਸ ਇਜ਼ ਦਾ ਮਾਈ ਵਿਊ।
ਇਹਨਾਂ ਕੋਲ ਵੀ ਪੁਰਾਣੇ ਕਾਉਂਸਲ ਸੀਗੇ, ਉਹਨਾਂ ਨੇ ਦੇਖਿਆ ਹੋਊਗਾ, ਇਹਨਾਂ ਨੇ ਦੇਖਿਆ ਨਹੀਂ ਹਲੇ ਡਿਟੇਲ ਚ।
ਸਰ ਐਕਚੁਅਲੀ ਮੇਰੇ ਕੋਲ ਜਿਹੜਾ ਹੈ ਇਸ 144 ਦਾ ਟਾਈਮ ਨਿਕਲਣ ਤੋਂ ਬਾਅਦ ਵਿੱਚ ਆਏ ਸਰ।
ਚਲੋ ਇਹ ਤਾਂ ਕੰਮ ਕਰ ਸਕਦੇ ਹੋ,
ਚਲੋ ਉਹ ਡਿਟੇਲ ਦੇਖ ਲਿਓ ਬਾਅਦ ਚ, ਕੋਈ ਐਡੀ ਗੱਲ ਨਹੀਂ।
ਪੋਰਟਲ ਤੇ ਸਾਰਾ ਕੁਝ ਮਿਲ ਜਾਏਗਾ ਇਹਨਾਂ ਨੂੰ।
ਹਾਂ
ਪੋਰਟਲ ਤੇ ਮਿਲ ਜਾਣਾ।
ਔਰ ਨਹੀਂ, ਉਹਦੇ ਵਿੱਚ ਇੱਕ ਰੈਮੇਡੀ ਤੁਸੀਂ ਇਹ ਵੀ ਕਰ ਸਕਦੇ ਹੋ ਟੂ ਆਈ ਮੀਨ ਤੁਹਾਡੀ ਡਿਮਾਂਡ ਘਟਣ। ਅਗਰ ਤੁਸੀਂ ਉਹ ਬੋਨਸ ਸੈਲਰੀ ਜੋ ਪਾਰਟਨਰ ਦੇ ਕੇਸ ਅਗਰ ਤੁਸੀਂ ਸ਼ੋ ਕੀਤੀ ਹੋਈ ਹੈ ਉਹ ਟੈਕਸ ਦਿੱਤਾ ਹੋਇਆ ਕਿ ਤੁਸੀਂ ਇੱਕ ਐਪਲੀਕੇਸ਼ਨ ਫਾਈਲ ਕਰਦੇ ਹੋ, ਕੋਲ ਵੀ ਵੀ ਹੈਵ ਆਲਰੇਡੀ ਪੇਡ ਦੀ ਟੈਕਸ ਔਨ ਦੈਟ ਅਮਾਉਂਟ ਇਨ ਦੀ ਹੈਂਡਸ ਆਫ ਦੀ ਇੰਡੀਵਿਜੂਅਲ ਅਸੈਸੀ ਐਜ਼ ਅ ਪਾਰਟਨਰ, ਸੋ ਇਟ ਵਿਲ ਬੀ ਡਬਲ ਟੈਕਸੇਸ਼ਨ। ਜਾਂ ਉਹਦਾ ਮੈਨੂੰ ਰਿਲੀਫ ਇੱਧਰ ਦਿਓ, ਕੁਝ ਐਡਜਸਟਮੈਂਟ ਕਰੋ ਉਹਦੀ। ਮਤਲਬ ਹਾਊ ਕੈਨ ਦੀ ਸੇਮ ਇਨਕਮ ਬੀ ਟੈਕਸ ਟਵਾਈਸ? ਮਤਲਬ ਸਮਝ ਰਹੇ ਮੇਰੀ ਗੱਲ?
ਸਰ ਹਾਂਜੀ ਸਰ, ਇਹ ਵਾਲੀ ਗੱਲ ਇਹਨਾਂ ਦੇ ਜਿਹੜੀ ਮੈਂ ਸਰ ਲਾਸਟ ਸਬਮਿਸ਼ਨ ਕੀਤੀ ਸੀ ਉਹਦੇ ਵਿੱਚ ਅਸੈਸਮੈਂਟ ਹੋਣ ਤੋਂ ਪਹਿਲਾਂ ਸਰ 17 ਤਰੀਕ ਨੂੰ ਦਾ ਰਿਪਲਾਈ ਦਿੱਤਾ ਸੀ, 17 ਮਾਰਚ ਨੂੰ ਸਰ। ਉਸ ਤੋਂ ਪਹਿਲਾਂ ਇਹ ਸਾਰੀ ਗੱਲ ਮੈਂ ਸਬਮਿਟ ਕਰ ਦਿੱਤੀ ਸੀ ਐਂਡ ਆਲਸੋ ਅਟੈਚ ਦੀ ਕੰਪੂਟੇਸ਼ਨ ਆਫ ਦੀ ਇੰਡੀਵਿਜੂਅਲ ਪਾਰਟਨਰਸ ਬੋਥ।
ਇਹਦਾ ਮਤਲਬ ਨੋਟਿਸ ਆਇਆ ਹੋਇਆ ਸੀ ਪਹਿਲਾਂ ਤੁਹਾਨੂੰ।
ਹਾਂ ਤਾਂ ਹੀ ਰਿਪਲਾਈ ਦਿੱਤਾ ਇਹਨਾਂ ਨੇ।
ਤਾਂ ਹੀ ਰਿਪਲਾਈ ਦਿੱਤਾ
ਸਰ। ਉਹੀ ਪ੍ਰੋਬਲਮ ਹੈ ਨਾ, ਜਦੋਂ ਨੋਟਿਸ ਆਉਂਦਾ ਨਾ ਉਦੋਂ ਸਾਨੂੰ ਬੜਾ ਕੇਅਰਫੁਲੀ ਕੰਪਲਾਈ ਕਰਨਾ ਚਾਹੀਦਾ ਹੈ ਕਿ
144 ਦਾ ਵੈਸੇ ਨਹੀਂ ਲੱਗਣਾ ਚਾਹੀਦਾ ਜਦੋਂ ਤੁਸੀਂ ਰਿਪਲਾਈ ਕਰਤਾ ਸੀਗਾ।
ਹੈ
ਜਦੋਂ ਰਿਪਲਾਈ ਕਰਤਾ ਸੀ 144 ਦਾ ਵੈਸੇ ਨਹੀਂ ਲੱਗਣਾ ਚਾਹੀਦਾ।
ਹੈ ਨਹੀਂ ਕੁਐਸਚਨ।
ਚਲੋ ਇਹ ਦੇਖ ਲਿਓ, ਥੋੜਾ ਜਿਹਾ ਸਪੈਸਿਫਿਕ ਕੇਸ ਹੋ ਗਿਆ।
ਜੈਨ ਸਰ ਮੈਂ ਇੱਕ ਵਾਰੀ ਤੁਹਾਨੂੰ ਡਾਕੂਮੈਂਟਸ ਨਾਲ ਮਿਲ ਲਾਂਗਾ ਸਰ ਇਹਦੇ ਲਈ, ਹੈ ਨਾ ਸਰ?
हाँ चलो, ये मतलब this inquiry or this query travels beyond the recovery।
Yes sir।
It will go to the assessment I mean procedure, क्योंकि 144 ਨੂੰ ਤੁਸੀਂ ਅਪੀਲ ਫਾਈਲ ਕਰਕੇ ਚੈਲੰਜ ਕਰੋ ਕਿ 144 has been wrongly invoked।
Yes।
ਹੈ ਨਾ ਕਿ we have made a compliance, ਮਤਲਬ ਇਸ ਤਰ੍ਹਾਂ ਉਹਨਾਂ ਨੂੰ ਇਹ onus is on the AO to establish that 144 is applicable in this case। So we have to make out a case कि 144 is not applicable and therefore whatever the allowances are available they should be allowed।
We have to see the facts and circumstances of the case।
हाँ, ये ਇਹਨਾਂ ਨੂੰ ਅਪੀਲ ਦੇ ਵਿੱਚ ਕੰਟੈਸਟ ਕਰਨਾ ਚਾਹੀਦਾ ਹੈ। ਅਪੀਲ ਫਾਈਲ ਕਰ ਦਿਓ। ਕੀਤੀ ਹੈ ਕਿ ਨਹੀਂ ਕੀਤੀ? ਅਪੀਲ ਫਾਈਲ ਨਹੀਂ ਕੀਤੀ ਉਹਨਾਂ ਨੇ?
ਨਹੀਂ ਸਰ, ਅਜੇ ਕਰਨੀ ਸੀ ਹਲੇ ਮੈਂ ਅਪੀਲ
ਫਾਈਲ। ਫਿਰ ਟਾਈਮ ਆਊਟ ਨਾ ਹੋ ਜਾਏ।
ਅਪੀਲ ਫਾਈਲ ਕਰ ਦਿਓ ਜ਼ਰੂਰ ਟਾਈਮ ਤੇ।
ਮਤਲਬ ਡੋਂਟ ਵੇਸਟ ਟਾਈਮ, ਕਿਉਂਕਿ ਫਿਰ ਲਾਸਟ ਡੇਟ 'ਚ ਨਾ ਕਈ ਵਾਰੀ ਹੈਂਗ ਹੋ ਜਾਂਦਾ ਸਿਸਟਮ ਹੀ।
ਰਾਈਟ।
ਹਾਂ ਨਹੀਂ ਬੜੀ ਪ੍ਰੋਬਲਮ ਹੈ। ਜਲਦੀ ਤੋਂ ਜਲਦੀ ਲਓ, ਡੋਂਟ ਵੇਟ ਫॉर।
ਮੇਰਾ ਇੱਕ ਕੁਐਸਚਨ ਸੀ
ਜੀ ਸਰ।
ਗੁਲਸ਼ਨ ਵਧਵਾ ਜੀ ਨੇ ਆਪਣਾ ਕੁਐਸਚਨ ਰੇਜ਼ ਕੀਤਾ ਕਿ ਪੋਰਟਲ ਤੇ ਜਿਹੜੀਆਂ ਪੁਰਾਣੀਆਂ ਡਿਮਾਂਡਸ ਬੋਲ ਰਹੀਆਂ ਨੇ 10 11 11 12 12 13 ਦੀਆਂ
ਜੀ,
ਕਾਫੀ ਡਿਮਾਂਡਸ ਐਸੀਆਂ ਨੇ ਜਿੰਦੇ ਚ ਐਸਐਸਸੀ ਨੇ ਟੈਕਸ ਜਮ੍ਹਾਂ ਕਰਾਏ ਹੋਏ ਔਰ 26 ਐਸ ਚ ਵੀ ਬੋਲ ਰਹੇ ਨੇ
ਜੀ।
ਹੁਣ ਜਿਹੜਾ CPC ਹੈ rectification application we cannot file because 4 years have elapsed. ਇਹੋ ਜਿਹੇ ਮੈਟਰਸ ਨੂੰ ਕਿਸ ਤਰ੍ਹਾਂ ਹੈਂਡਲ ਕੀਤਾ ਜਾਏ, ਗ੍ਰੀਵੈਂਸ ਦੇ ਥਰੂ ਜਾਂ ਜੁਰਿਸਡਿਕਸ਼ਨਲ ਇਹ ਨੂੰ ਲਿਖ ਕੇ ਕੀਤਾ ਜਾਏ with the facts and figure ਕਿ these are the challans we have deposited, ਜਾਂ 26S ਦੀਆਂ ਫਿਗਰ ਬੋਲ ਰਹੀਆਂ ਨੇ, ਉਹਦੇ ਵਿੱਚ ਤੁਸੀਂ ਡਿਲੀਟ ਕਰੋ ਡਿਮਾਂਡ ਪੋਰਟਲ ਤੇ।
ਨਹੀਂ ਜਿਹੜੀ ਡਿਮਾਂਡ ਨਹੀਂ, ਇਹ ਮਤਲਬ ਕੁਐਸਚਨ ਇਹ ਹੈ ਕਿ ਜਿਹੜੀ ਡਿਮਾਂਡ ਦੇਖੋ 154 ਅਗਰ ਤੁਸੀਂ ਲਗਾ ਰਹੇ ਹੋ ਤੇ ਉਹ
154 ਵੀ ਸੇ ਆਪ ਐਪਲੀਕੇਸ਼ਨ ਨਹੀਂ ਦਿੱਤੀ, ਭੁੱਲ ਗਏ ਉਸ ਟਾਈਮ।
ਨਹੀਂ ਕੁਐਸਚਨ ਇਹ ਹੈ ਕਿ
ਡਿਮਾਂਡਸ ਹੁਣ ਸਾਹਮਣੇ ਆ ਰਹੀਆਂ ਨੇ ਔਰ ਟੈਕਸ ਜਮਾ ਨੇ, SSC ਦੇ ਕੋਲ ਐਵੀਡੈਂਸ ਵੀ ਹੈਗਾ।
ਹਾਂ
ਕੁਝ ਕੇਸੇ 26S ਹੈਗੇ ਨੇ, ਕੁਝ ਕੇਸੇ ਚਲਾਨ ਵੀ ਹੈਗੇ ਉਹਨਾਂ ਕੋਲ।
ਦੇਖੋ ਇਹਦਾ I think the better way is to meet the concerned AO and the concerned head of that AO ਔਰ ਦਾ ਜਿਹੜਾ immediate head ਹੈ ਨਾ, ਉਹਨੂੰ ਮਿਲ ਕੇ ਉਹਨੂੰ ਦੱਸੋ ਵੀ this is the position we have paid the tax and this is the evidence, because it is the AO who has to delete the demand unless the, ਕਿਉਂਕਿ demand ਚੜਾਈ ਵੀ AO ਨੇ ਹੋਈ ਹੈ। ਇਹ ਜਿਹੜੀ
AO ਪੁੱਛਦਾ ਕਿ tell me the procedure, how should I do?
ਦੇਖੋ ਇਹਦੇ ਵਿੱਚ ਪਤਾ ਕੀ ਹੈ, ਇਹ ਟੈਕਨੀਕਲ ਕਲਾ ਨੇ, ਇਹਦੇ ਵਿੱਚ ਉਹਨਾਂ ਯੂ ਮੀਟ ਦੀ ਕਮਿਸ਼ਨਰ ਐਂਡ ਕਮਿਸ਼ਨਰ ਵਿਲ ਸਪੀਕ ਟੂ ਦੀ ਟੈਕਨੀਕਲ ਸਿਸਟਮ ਦੇ ਵਿੱਚ ਇਹਨਾਂ ਦੇ ਬੰਦੇ ਹੈਗੇ ਨੇ।
ਓਕੇ
ਮਤਲਬ ਯੂ ਮੀਟ ਦੀ ਕਮਿਸ਼ਨਰ and he will find a way out because they have technical people in their department to delete such demands which are bogus demands, which are infructuous demands. ਇਹਨਾਂ ਕੋਲ ਹੈਗਾ ਸਿਸਟਮ। ਮੈਨੂੰ ਯਾਦ ਹੈ ਮੈਂ ਇੱਕ ਵਾਰੀ ਇੱਥੇ ਕਮਿਸ਼ਨਰ ਕੋਈ ਆਇਆ ਸੀ, I don't know what was his name, ਮੇਰਾ ਖਿਆਲ ਉਹ ਲੁਧਿਆਣੇ ਦਾ ਕਮਿਸ਼ਨਰ ਸੀ, ਉਹਦਾ ਐਡੀਸ਼ਨਲ ਚਾਰਜ ਸੀ ਜਲੰਧਰ, ਐਂਡ I told him ਕਿ ਮੇਰੀਆਂ ਡਿਮਾਂਡਸ ਜਿਹੜੀਆਂ ਨੇ ਮੈਂ ਪੇ ਕੀਤੀਆਂ ਹੋਈਆਂ ਨੇ, they are still in the portal, ਔਰ ਮੈਂ VSV ਫਾਈਲ ਕੀਤਾ, ਉਹਦੇ ਵਿੱਚ ਉਹ ਡਿਮਾਂਡ ਕੱਢ ਕੇ ਭੇਜਤੀ ਉਹਨਾਂ ਨੇ। ਮੈਂ ਉਹਨੂੰ ਕਿਹਾ, ਮੈਂ ਕਿਹਾ ਜੀ these demands have been recovered by the department, I have the challans also, and still they are showing this demand in the portal and they are saying that under VSV I am liable to pay this much of amount, whereas I say that I have not to pay anything, I am claiming refund. How the demand? I gave him the evidence. Then I think he called his ITO judicial or somebody, and he said, you make me talk to that man in the systems, I will speak to him and he will get me some remedy.
Even sir, ਕੁਝ ਕੇਸਿਸ ਚ ਲੇਟੈਸਟ ਮੈਟਰਸ ਹੈਗੇ ਨੇ, SSC ਦੀਆਂ ਜਿਹੜੀਆਂ ਡਿਮਾਂਡਸ ਖੜੀਆਂ ਨੇ ਉਹ 26S ਚ ਬੋਲ ਰਹੀਆਂ ਕਿ ਜਮਾ ਹੋਈਆਂ ਹੋਈਆਂ, and we have filed the rectification application also to the CPC, but still CPS is not recognizing that part. ਇਹਨਾਂ ਦਾ ਜਿਹੜਾ ਆਪਣੇ ਪੋਰਟਲ ਹੀ ਆਪਸ ਵਿੱਚ ਲਿੰਕ ਨਹੀਂ ਹੈਗੇ, ਟੂ ਮਾਈ ਮਾਈਂਡ। 26S ਕੁਝ ਕਹਿ ਰਿਹਾ, ITBA ਕੁਝ ਕਹਿ ਰਿਹਾ, ਇਹਨਾਂ ਦਾ
ਫਿਰ ਤਾਂ CPGram ਪਾ ਦਿਓ, best evidence, best remedy ਹੈ।
Okay,
CPGram is a better option, sir. I also know.
ਨਹੀਂ, it is matter of assessment, but it is a matter of concern because it's a general problem everywhere. ਇਹਦਾ ਤਾਂ CPGram ਪਾ।
okay.
ਮੋਹਨ ਜੀ 6:30 ਵੱਜ ਗਏ, ਚਲੋ ਹੁਣ
Sir, there is one last query. Gulshan Badwa ji has called me. He said he has to leave somewhere. I think Mr. Sangam will take the query of Rupinder ji.
ਜੇ ਰੁਪਿੰਦਰ ਢਾਂਡੀ ਦੀ ਕੁਐਰੀ ਹੈ ਨਾ, ਉਹ ਰੁਪਿੰਦਰ ਢਾਂਡੀ ਦੀ ਕੁਐਰੀ ਆ 148 ਸੈਕਸ਼ਨ ਤੇ ਆ, ਉਹ ਦੁਆਰਾ ਜਾਂ ਇੰਡੀਵਿਜੂਅਲੀ ਦੇਖ ਲੈਣਗੇ, ਕਿਉਂਕਿ 6:30 ਵੱਜ ਗਏ ਆ। ਵੀ ਸ਼ੁਡ ਆਈ ਥਿੰਕ ਕਲੋਜ਼।
ਨਹੀਂ ਜੇ ਕਰਨੀ ਹੈ ਕਰ ਲਓ, ਕੋਈ ਗੱਲ ਨਹੀਂ।
ਚਲੋ ਰੁਪਿੰਦਰ ਜੀ ਨੂੰ ਹੀ ਕਰ ਦੇਣਾ। ਹਾਂ ਗੁਲਸ਼ਨ ਸੰਗਮ ਜੀ ਲੈ ਲਓ।
Sir, Rupinder ji ki query hai, in one of my client case we have filed return under section 148 on 24th March 22. AO passed assessment order on 28th March 22. By mentioning return filed under section 148 is not acceptable as it is not verified, therefore he charged interest etc. But he accepted what we have filed in return. Please enlighten me whether it is justified not to accept the return when time of 120 is still not elapsed, whether we file appeal or rectification.
You see, the return filed beyond the time of the notice. Basically, when you get a notice, there is a time limit of 30 days. If you don't file the return in 30 days, then that is not a valid return. Unless you get another notice under 142(1) with the extension that you file a return. Because 148 return, if not filed within 30 days, is no return. It is an invalid return. And if the AO takes cognizance of that return while passing the order, then it is an illegal order. Because an illegal return will result in an illegal order. You can take this ground in appeal also. But if you say that your return has been taken cognizance of and it is beneficial to you, मतलब एक legal ground है जिसमें पहला दस रहा था. On facts, what you can do that if he says that because you have not got the return verified, e-verification ਦੀ ਗੱਲ ਕਰ ਰਹੇ ਹੋ ਨਾ, ਹੈ ਨਾ, ਤੇ ਫਿਰ ਉਹਦੀ ਕੰਡੋਨੇਸ਼ਨ ਆਫ ਡਿਲੇ ਪਾ ਕੇ ਦੇਖੋ ਜੇ ਹੋ ਸਕਦੀ ਹੈ ਡਿਲੇ ਕੰਡੋਨ ਕਰਾ ਲਓ ਕਮਿਸ਼ਨਰ ਕੋਲੋਂ ਜਾਂ ਉਹਦੇ ਚ ਜਾਂ ਨਹੀਂ ਉਹ ਸੀਪੀਸੀ ਕੋਲ ਵੀ ਕੋਈ ਪਾਵਰ ਹੈਗੀ ਹੈ ਡਿਲੇ ਕੰਡੋਨ ਕਰਨ ਦੀ ਔਨ ਸਿਸਟਮ ਫਾਈਲ ਹੁੰਦੀ ਹੈ ਸ਼ਾਇਦ ਯੂ ਕੈਨ ਅਪਲਾਈ ਫॉर दैट ਆਲਸੋ I don't know whether they will accept it now because they have passed the assessment order, but in normal cases we have tried this method that where a return is filed but verification is delayed, some condonation power is there with the CPC. They accept the verification even after the lapse of that time. ਤੁਸੀਂ ਦੇਖ ਲਓ ਜੇ ਕੰਡੋਨੇਸ਼ਨ ਹੋ ਸਕਦੀ ਹੈ ਤੇ ਨਹੀਂ ਹੋ ਸਕਦੀ ਹੈ ਤੇ ਟੇਕ ਅ ਲੀਗਲ ਗਰਾਊਂਡ that if my return was not there, then the order passed on the basis of that return. If it starts from your return income and then addition for assessment income, then that means there is a I think high court case Kolkata high court hai ya keda hai ki illegal return matlab beyond time the return is illegal and if 143(2) issued or not issued je tusi 24 ਨੂੰ return ਕੀਤੀ ਹੈ 28 ਨੂੰ ਉਹਨੇ ਕਰਤਾ ਤੇ return ਉਹਨੇ 143(2) ਤੇ issue ਹੀ ਨਹੀਂ ਕੀਤਾ ਹੋਣਾ you can take a ground also ki 143(2) was not issued although he starts with my return income he should start with nil agar meri income ਨੂੰ ਨਹੀਂ ਲੈ ਰਿਹਾ return ਨੂੰ then he should start return income nil addition so and so the assessed income is so and so. But if he starts with your return income that means he is taking cognizance of your return and if he is taking cognizance of your return then it means an invalid return which he himself has certified will render the order also illegal. ਇਹ ground ਲੈ ਲਓ appeal ਦੇ ਵਿੱਚ ਔਰ ਉਹਨੂੰ ਬਾਅਦ ਵਿੱਚ ਆਪਣੀ arguments ਨੂੰ ਤਿਆਰੀ ਕਰਨਾ with some case law you will find out from the net ਲੱਭ ਜਾਣੇ ਤੁਹਾਨੂੰ ਗੂਗਲ ਤੇ ਸਰਚ ਮਾਰ ਕੇ ਦੇਖਣਾ ਠੀਕ ਹੈ ਜੀ
Right.
Thank you, sir. Thank you very much.
Yes.
Now I think it's time to close our meeting. I would now request our newsletter editor CAHK Aneja ji to share his views and give concluding remarks and formal vote of thanks. Sir, please.
Thank you, all my friends. First of all, I am highly feeling privileged that I have been provided the opportunity to give the concluding remarks of this highly enriched session delivered by Mr. Joravar Singh Bhasin ji. Really, he elucidated the matter in detail, very well explained. This topic was almost untouched since many long time. This topic is very of great importance in today's time, particularly when high-pitched assessments are being made and heavy demands are being created. So I am just summing up his whole speech, what he has given, whole deliberation, what he has given to my mind. Wherever assessee has filed the appeal and there is a heavy demand, as per the circumstances of the case, he should move application, though it is not required under section 226, but still, whenever the situation demands, he should move application, giving the whole merits of the case. Particularly, Bhasinji mentioned merits of the case, financial contingency, and balance of convenience. All 3 points he should raise, he should elaborate in his application, so that AO could take cognizance of all the situation and decide the things on merits. Further, normally what we people see, ki AO generally pass the one line in order, ki demand is not stayed. In these cases, there are umpteen number of cases. Even the jurisdictional Punjab and Haryana High Court says ki AO is expected to give the opportunity of hearing to the assessee if he has to pass an adverse order. And if he has not a pass, if he has a passed adverse order, he should give the opportunity. And normally High Courts set aside such orders and again refer the matter to the AO to pass a speaking order after giving a reasonable opportunity of hearing to the assessee. Next part. ਜਿਹੜੀਆਂ instructions ਨੇ mainly 2016 ਦੀਆਂ ਔਰ 2017 ਦੀਆਂ, ਉਹਨਾਂ ਦਾ sum up mainly ਇਹੀ ਹੈਗਾ ਕਿ ਜਿਹੜਾ stay ਦਾ ਜਿਹੜਾ right ਹੈਗਾ ਉਹ assessee ਦੇ ਕੋਲ unfettered right ਨਹੀਂ ਹੈ. It will depend upon the facts and circumstances of the case. 20% ਜਿਹੜੀ demand ਹੈਗੀ ਹੈ, that amount can be raised also and that amount can be lessened also. There are judicial decisions ਜਿੱਥੇ AO ਨੇ 20% ਕਿਹਾ ਹੈ, but the assessee ਦੇ case ਦੇ merits demand ਕਰਦੇ ਸੀ, high pitched demand ਸੀ ਕਿ courts have held that ਕਿ demand should be lowered according to the situation and stayed the demand also. Further, ਜਿਹੜਾ ਸੈਕਸ਼ਨ ਉਹਨਾਂ ਨੇ 254 2A ਟੱਚ ਕੀਤਾ ਹੈ ਟ੍ਰਿਬਿਊਨਲ ਦੀ ਪਾਵਰ ਦਾ, ਉਸ ਦੇ ਵਿੱਚ ਵੀ ਰੀਸੈਂਟ ਲਾਸਟ ਈਅਰ ਕੇਸ ਆਇਆ ਸੁਪਰੀਮ ਕੋਰਟ ਦਾ ਪੈਪਸੀ ਫੂਡ ਦਾ ਕੇਸ ਦੇ ਵਿੱਚ ਸੁਪਰੀਮ ਕੋਰਟ ਨੇ ਇਹ ਕਿਹਾ ਕਿ ਜਿਹੜਾ 365 ਡੇਜ਼ ਟਾਈਮ ਦਿੱਤਾ ਹੈਗਾ ਸਟੇ ਦਾ, ਉਹ ਆਟੋਮੈਟਿਕਲੀ ਵਿਕੇਟ ਨਹੀਂ ਹੋਣੀ ਚਾਹੀਦੀ ਜਿੱਥੇ ਅਸੈਸੀ ਦਾ ਕੋਈ ਫਾਲਟ ਨਹੀਂ ਹੈ, ਬਿਕੋਜ਼ ਜਿੰਨੇ ਤੱਕ ਅਸੈਸੀ ਦਾ ਕੋਈ ਫਾਲਟ ਨਹੀਂ ਹੈ, up to that extent this section is violative of article 14 of the constitution. ਉਹਨਾਂ ਨੇ ਇਹ ਕਿਹਾ ਹੈਗਾ। In other words, a tribunal can give the time beyond 365 days on fresh application made by the assessee, where assessee is not having any default on that part. Even he has fully cooperated. In such cases, he can move the application. ਬਾਕੀ ਜਿਹੜਾ ਰਿਕਵਰੀ ਦਾ ਪਾਰਟ ਉਹਨਾਂ ਨੇ ਬਹੁਤ ਅੱਛੀ ਤਰ੍ਹਾਂ ਐਕਸਪਲੇਨ ਕੀਤਾ। I still remember in the times of 80s ਜਦੋਂ ਅਸੀਂ TRO ਦੇ ਆਫਿਸ 'ਚ ਜਾਂਦੇ ਸੀ ਤਾਂ ਉਹਨਾਂ ਦੇ ਪਿੱਛੇ ਹੱਥਕੜੀ ਖੜੀ ਕੀਤੀ ਹੁੰਦੀ ਸੀ, ਲਗਾਈ ਹੁੰਦੀ ਸੀ। ਉਹਦਾ ਮਤਲਬ ਇਹ ਸੀ ਕਿ we have a power to arrest you if you will not cooperate। ਤਾਂ ਉਸ ਕੇਸ ਦੇ ਵਿੱਚ ਇਹਨਾਂ ਨੇ ਅੱਜ ਬੜੀ ਇੱਕ ਅੱਛੀ ਚੀਜ਼ ਸਾਡੀ ਨੌਲੇਜ 'ਚ ਇਨਕਰੀਜ਼ ਕੀਤੀ ਹੈ ਕਿ TRO has a concurrent jurisdiction with the AO। ਅਗਰ ਆਪਣੀ ਐਪਲੀਕੇਸ਼ਨ AO ਕੋਲ ਪੈਂਡਿੰਗ ਹੈ ਰੈਕਟੀਫਿਕੇਸ਼ਨ ਦੀ, the TRO is expected to take cognizance of that. He has to amend his order. This is a very good enrichment of knowledge. Further ਜਿਹੜੀ ਚੀਜ਼ ਇਹਨਾਂ ਨੇ ਇਹ ਕਹੀ ਹੈਗੀ ਹੈ ਆਪਣੇ ਸਾਰਿਆਂ ਦੇ ਗਾਈਡੈਂਸ ਲਈ ਔਰ ਨੌਲੇਜ ਲਈ, ਬਿਕੋਜ਼ ਹੁਣ ਜਿਹੜਾ ਟਾਈਮ ਹੈ ਟੋਟਲੀ ਚੇਂਜ ਹੋ ਗਿਆ, ਫੇਸਲੈਸ ਹੋ ਗਿਆ, ਇਲੈਕਟ੍ਰੋਨਿਕ ਦਾ ਟਾਈਮ ਆ ਗਿਆ। ਸਾਨੂੰ ਅਸੈਸਿਸ ਨੂੰ ਵੀ ਗਾਈਡ ਕਰਨਾ ਚਾਹੀਦਾ ਹੈ ਕਿ ਤੁਸੀਂ ਆਪਣੇ ਆਪ ਦੇ ਵਿੱਚ ਕੌਨਸ਼ੀਅਸ ਰਹੋ। ਅਗਰ ਕੋਈ ਡਿਪਾਰਟਮੈਂਟ ਤੋਂ ਕੋਈ ਮੇਲ ਜਾਂ ਨੋਟਿਸ ਆਉਂਦਾ ਹੈ, ਦੇ ਸ਼ੁੱਡ ਇਨਫੋਰਮ ਅਸ। ਉਸ ਦੇ ਵਿੱਚ ਵਟ ਵੀ ਪੀਪਲ ਡਿਡ, ਅਸੀਂ ਜਿੰਨੇ ਵੀ ਸਾਡੀਆਂ ਰਿਟਰਨਸ ਨੇ ਇਨ ਆਲਮੋਸਟ ਆਲ ਦਾ ਕੇਸਿਸ, ਅਸੀਂ ਈਮੇਲ, ਟੈਲੀਫੋਨ ਨੰਬਰ that has been given of the assessee, so that burden should lie on the assessee to pass the information to us, so that we could not be held accountable subsequently if something adverse happens. ਬਾਕੀ ਫਰਦਰ ਮੈਂ ਇੱਕ ਚੀਜ਼ ਐਡ ਕਰਨਾ ਚਾਹੂੰਗਾ। 226(3) ਦੇ ਕੁਝ ਨੋਟਿਸ ਮੈਨੂੰ ਡੀਲ ਕਰਨ ਦਾ ਮੌਕਾ ਮਿਲਿਆ ਹੈ। ਕਾਫੀ ਕੇਸਿਸ 'ਚ ਡਿਪਾਰਟਮੈਂਟ ਕੀ ਕਰਦਾ ਹੈ ਕਿ ਬੈਂਕਰਸ ਨੂੰ ਲੈਟਰ ਸਟ੍ਰੇਟਵੇ ਭੇਜ ਦਿੰਦਾ ਹੈਗਾ ਕਿ ਇਹਨਾਂ ਦੇ ਬੈਲੈਂਸ ਜਿਹੜਾ ਅਕਾਊਂਟਸ ਹੈਗਾ ਉਹ ਤੁਸੀਂ ਸਾਨੂੰ ਭੇਜ ਦਿਓ, ਉਹਨਾਂ ਨੂੰ ਡੈਬਿਟ ਕਰਕੇ। ਔਰ ਕਾਫੀ ਕੇਸਿਸ ਦੇ ਵਿੱਚ ਨਾਰਮਲੀ ਵਟ ਵੀ ਪੀਪਲ ਫਾਈਂਡ ਕਿ ਅਸੈਸੀ ਦਾ ਕਰੰਟ ਅਕਾਊਂਟ ਨਹੀਂ ਹੁੰਦਾ, CC ਅਕਾਊਂਟ ਹੁੰਦਾ ਹੈ। ਤਾਂ ਦੇਰ ਆਰ ਡਿਸਾਈਡਡ ਜਜਮੈਂਟਸ ਕਿ ਜਿੱਥੇ CC ਅਕਾਊਂਟ ਹੈਗਾ ਉੱਥੇ ਬੈਂਕਰ ਕੈਨ ਨਾਟ ਰਿਮਿਟ ਦਾ ਪੇਮੈਂਟ, ਬਿਕੋਜ਼ ਦੇਰ ਆਰ ਨੋ ਡਿਊਜ਼ that we have to take from the bank, rather we have to give dues to the bank. In such cases, in one of my case, bank ने payment withheld कर ली और उसने उसे फिर final notice देता कि you will be held accountable because you cannot do this, and ultimately he has detached the amount and he has not sent the amount after considering our reply.
That's very good.
And further in 226(3) ਚ ਕਾਫੀ ਕੇਸਿਸ ਡਿਪਾਰਟਮੈਂਟ ਕੋਲ ਜਿਹੜੀ ਇਨਫੋਰਮੇਸ਼ਨ ਹੁੰਦੀ ਹੈ ਉਹਦਾ ਬੇਸਿਸ ਆਫ ਬੈਲੈਂਸ ਸ਼ੀਟ ਹੁੰਦੀ ਹੈ ਔਰ ਉਹ ਡੈਟਰਸ ਨੂੰ ਨੋਟਿਸ ਭੇਜ ਦਿੰਦਾ ਜਿਨ੍ਹਾਂ ਕੋਲ ਅਸੀਂ ਕਰੈਕਸ਼ਨ ਲੈਣੀ ਹੁੰਦੀ ਹੈ। ਔਰ ਕਾਫੀ ਕੇਸਿਸ 'ਚ ਜਦੋਂ ਐਸੇ ਨੋਟਿਸ ਆਉਂਦੇ ਨੇ, ਜਦੋਂ ਅਸੀਂ ਕਰੰਟ ਸਿਚੁਏਸ਼ਨ ਡਿਮਾਂਡ ਕਰਦੇ ਹਾਂ ਤਾਂ ਉਹ ਅਮਾਊਂਟ ਐਡਜਸਟ ਹੋ ਚੁੱਕੀ ਹੁੰਦੀ ਆ, ਆਈਦਰ ਬਾਈ ਵੇ ਆਫ ਪਰਚੇਜ਼ ਫਰੋਮ ਦੈਟ ਪਾਰਟੀ ਔਰ ਬਾਈ ਰਿਸੀਟ ਆਫ ਪੇਮੈਂਟ। In that case also we can make representation कि this nothing is due from that party, and our debtor can also take this plea कि we have nothing to pay to that party, so we cannot pay this amount to you. बाकी मैं जोरावर जी का बहुत बहुत आभारी हाँ जिन्हों ने टाइम कट के बड़े इंपॉर्टेंट टॉपिक थे और बड़े एक क्रूशियल टाइम थे जिहड़ी डेलीब्रेशन दी है कि जिस दे नाल साडी सारी फ्रेटर्निटी fully enriched हुई है। I am highly thankful to it. Further, I am highly thankful to the convener of the study circle, Mr. Rajiv Kochal, and his entire team for arranging this webinar in such a short span of time. Lastly, I am highly thankful to all the participants because without their participation, this webinar could not have been so much success which it has been there. Thank you very much.
Thank you.
Thank you, sir. Thank you very much.
Thank you, Bhasin Saab. Thank you very much
So much, sir.
for sparing your valuable time and enlightening us, all of us, so brilliantly.
It's
Thank
my
you very
pleasure. It's my pleasure to be with you all. Thank you so much.
Thank you, sir. Thank you for coming.
Thank you.
Jansa, we should close the